Anna? Hello?
Hey, John.
Hey, what's this for?
I don't think you need to be on this. This is my hearing that I was telling you about yesterday.
Okay. Well, because I got this notice just now that it said evidentiary hearing in case number 20-00236-UT, which is the SPS financing case. So I was freaking out a little bit.
It's all good.
Okay. This is for 218, right?
This is for 218 where, yeah, we had a little bit of technical difficulties when we first started up.
Okay.
So
well, you might let them know that the notice they just issued had case number 20-00236 in the title. So it might lead to some confusion or panic depending on who you're talking to.
Okay.
All right. Thanks. I'm going to get out of here. I'll talk to you later.
Have a good one.
All right. You take care. Bye.
Yep.
Skip and Brock? Did you hear the discussion between Mr. Vagatko and Mr. Borman?
I heard a little bit. I need to check with, see how we can fix that problem.
Okay, I think most folks will hopefully figure out that it's
To be frank, I didn't even look at the case number. I mean, I guess because of the discussion before, I figured what this probably was. So,
nor did I. I just I'm so anxious. I just clicked on the link. As soon as
you
I
and me
saw
both.
I just hit reply all, and I noted this invitation is for 20-00218.
The question now obviously goes to what is showing up on YouTube with regard to what stream we're on. And since we are live streaming this, I should note that we had some technical difficulties. And this is, I'm not on the record yet. I haven't gone on the record yet, but for those of you out there, this will be a public hearing in the matter of PNM's application for approval of a demand response program. It's noticed on the top of the commission's website, and this is obviously case number 20-00218-UT, not what may be reflected in the invitation that the Zoom invitees received. For those participants in the hearing, which are counsel for the parties and the witnesses. I'm still admitting some folks. We may have close to a full contingent now for the hearing. But I want to check with Ms. Kippenbrock to make before I do convene the hearing. Okay, Anna, if you're there, would it be all right for me to go ahead and start? Are we set up on YouTube okay now? I do see at the top of my Zoom meeting screen here that we are live on YouTube, but I'm fearful of leaving and going out and checking that on my own. So I'm checking with you, Anna, to see whether we're okay to go. We're good to go.
Mr. Hearing Examiner, I clicked on the link and it is working. YouTube is streaming live
Okay, great.
now.
Thank you. Yeah, I've been instructed before not to have both streams going at once. That's why I didn't do that. Thank you, Ms. very much for doing that. So unless I hear from Ms. Kippenbrock in the next couple of 30 seconds, I'm going to go ahead and just start the hearing. We'll go on the record. And I'll let you know, Allison, when I'm starting. See if we have all the participants here that we should have. Hard to tell, but I haven't had anybody request that I haven't seen before. I haven't seen anybody request admittance that hasn't already been invited to the hearing. And I and Ms. Kippenbrock will be checking to ensure that everybody who's been invited is admitted to the meeting. Okay, Allison, you ready? Okay, great, thank you. We're going on the record now. Good morning, all. The hearing will please come to order. This is the time and place set for the public hearing in this proceeding, which is docketed as the New Mexico Public Regulation Commission case number 20-00218-UT. My name's Anthony Medeiros. I'm the hearing examiner assigned by the commission to preside over this matter and issue a recommended decision to the commission on the merits of Public Service Company of New Mexico's application for approval of, among other things, a new demand response plan pursuant to the final order in case number 19-00195-UT. The subject application was filed in this case on November 13, 2020. The hearing is being held in accordance with the procedural order entered in this docket on November 25, 2020. The notice of proceeding and hearing, also issued on that date, was timely published by PNM in the Farmington Daily Times on November 30th, 2020, and the Albuquerque Journal on December 2, 2020. 2020, that's right. The notice was also promptly posted on PNM's regulatory information webpage. Would the parties please enter their appearances now, starting with the applicant, PNM.
Good morning, Mr. Medeiros. This is Ryan German. Excuse me. And with me is Ray Gifford, and we're appearing on behalf of PNM.
Good morning, Mr. German. Thank you. And again, apologies for the delay. This goes to all of you who are entering appearances now. Anybody from the city of Albuquerque with us? How about the Attorney General of New Mexico?
Good morning, Mr. Hearing Examiner. Robert.
Good morning, sir. Bernalillo County? How about the Central Consolidated School District and New Mexico Legislative Delegation of San Juan County? Citizens for Fair Rates and the Environment? Coalition for Clean Affordable Energy?
Good morning. Stephanie Zur appears today on behalf of Coalition for Clean Affordable Energy. And I have with me today our witness, Justin Brandt from SWEET.
Good morning. Thank you, Ms. Zur.
Thank you.
the International Brotherhood of Electrical Workers, Local 611, and International Union of Operating Engineers, Local 953. How about the Interwest Energy Alliance?
Joan Drake appears for the Interwest Energy Alliance. Thank you.
Thank you, ma'am. Los Alamos County and MSR Public Power. New Mexico Affordable Reliable Energy Alliance. That's still a mouthful for me, Mr. Gould.
I always get it wrong when I keep on saying NIMIAC, but my
Yeah,
clients are not happy about that. But yes, Peter Gould and my co-counsel, Kelly Gould, on behalf of NM area. And if you'll notice, we have Selah Kaiser, who is our office assistant. She's on, but she's not going to be participating. She's just helping the technically challenged older partner of this law firm.
You're not technically challenged, Mr. Gould, but I appreciate that. And Ms. Kaiser is welcome at this point. Thank you.
Thank you.
New Energy Economy, Prosperity Works. How about San Juan Citizens Alliance and Diné, Citizens Against Ruining Our Environment? How about San Juan County and City of Farmington? Sierra Club, Greg Sonnenfeld, Southwest Generation Operating Company, Western Resource Advocates.
Good morning, Sydney Beatles for Western Resource Advocates, and I have to think twice to make sure I don't say staff.
Yeah, you do. I do too. But thank you for hanging in there with us, Ms. Beatles. Good morning.
Good morning.
Westmoreland Coal. And last but not ever least, staff.
Thank you, Mr. Hearing Examiner, and good morning. My name is Bradford A. Borman. Appearing on behalf of Utility Division staff, I am joined with my witness, John Reynolds, the Utility Division Director.
Good morning to you both. Thank you, sir. The list of names for those of you who may not be familiar with the case, there was a long list of interveners parties that I just went through. Those parties were made interveners to this case pursuant to my procedural order, in this case, the November 25/20 procedural order, at the request of the applicant PNM, that parties, I believe at the request of the applicant, that parties to, or at the suggestion of at least PNM, that parties to case 19-195 UT and 20-0018 UT. Those are the PNM replacement resources for the San Juan Generating Station case and the supplemental replacement resources case dockets respectively. All of those parties that I just went through and asked whether they were on the line or on the Zoom hearing with us here. Those parties were parties to those cases and were made parties to the case. Those who are not participating in the case will suffer no consequences of not having participated in this case, given the way that they were obviously made parties to the case. Now on to preliminary issues. The first order of business is whether there's any objection to taking administrative notice of the evidentiary records in case numbers 19-00195-UT, that being the San Juan Replacement Resources case, and 20-0018 UT, the San Juan Supplemental Replacement Resources case. Is there any objection to taking administrative notice of the evidentiary records of those cases?
No, sir.
Let me add, there's one piece of testimony. I went back and looked at the recommended decision in case number 20-00182 UT. The parties there stipulated to the admission of all the testimony in that case. One of the pieces of testimony in that case was Mr. Phillips' testimony in 20-00182 UT.
Mr. Phillips also obviously filed direct testimony and rebuttal testimony in this case. I'd like to propose that the direct testimony in 20-00182 UT also be included in the, just for clarification, that testimony is included in the evidentiary record of which the commission would take administrative notice. Is there any objection to taking administrative notice of that Phillips testimony in the former case?
No objection.
Thank you. Hearing no objection, the entire list of testimonies in 20-018 UT, along with the rest of the evidentiary record in both of those cases, will be taken administrative notice of. The second issue that I have is excusing Mr. Mark Fenton, who filed direct testimony in this case, as well as the other two cases, but most particularly in this case, whether the parties will stipulate to the admission of his direct testimony in this case. Is there any objection to excusing Mr. Fenton from testifying? No. Hearing none, Mr. Fenton is excused from testifying, and his direct testimony is admitted as, I believe, PNM, is it PNM Exhibit 1?
Yes, PNM Exhibit 1.
Okay. PNM Exhibit 1 is thereby admitted into the record. The third issue is that the record should also reflect that pursuant to the procedure order and notice, interested persons not affiliated with the party were afforded the opportunity to provide oral comment at the beginning of this hearing, but no one registered in advance to give oral comment. However, interested persons viewing the hearing via the live YouTube stream that we're lucky enough to have now should note that, as also reflected in the procedure order notice, written comments may be submitted before the commission takes final action in this case by sending the comment, which shall reference this case docket number 20-00218-UT to prc.records@state.nm.us. Finally, I should mention that PNM filed a notice on January 5, 2021, confirming the company's agreement to cover the incremental cost of an expedited hearing transcript for this hearing. We'll discuss this matter further at the end of the hearing. Are there any other issues the parties may wish to address before we turn to the presentation of evidence? Very well, hearing none. Pause again because this is Zoom. I don't see any hands up. We'll turn now to the presentation of evidence, and pursuant to 1.2.233B NMAC of the Commission's Rules of Procedure, the order of presentation and receipt of evidence will be as follows. The burden of going forward with the evidence and proving the merits of the relief requested in the application in accord with governing legal standards, which we'll address as the hearing goes along, and at the end of the hearing, by a preponderance of the evidence, is with the applicant, PNM. PNM's witnesses will be followed by CCA's witness and then staff's witness after that. Consequently, Mr. Chairman, would PNM please call its first witness?
Yes, Mr. Gifford will present Mr. Phillips.
Thank you, Your Honor. Mr. Phillips, you are with us and you are unmuted. Is that correct?
Yes, I am.
Could you please state Your Honor, do we need to swear him?
Yes.
Mr. Phillips, do you solemnly swear or affirm the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you.
Good morning, Mr. Phillips.
Good morning.
Mr. Phillips, could you state your name and what you do for the record?
My name is Nicholas L. Phillips. The last name is spelled Phillips, and I'm the Director of Integrated Resource Planning for Public Service Company of New Mexico.
And Mr. Phillips, do you have in front of you what has been pre-marked as PNM Exhibit 2 and PNM Exhibit 3, consisting of PNM Exhibit 2, the direct testimony of Nicholas Phillips, and PNM Exhibit 3, the rebuttal testimony of Nicholas Phillips?
Yes, I do.
And Mr. Phillips, if I were to ask you those same questions here live, would you give the same answers as are contained in the pre-filed exhibits?
Yes, I would.
Do you have any corrections to either of those exhibits?
I have one correction to my direct testimony. It is not made in the version in Dropbox. If I could, I'd like to make that now.
Please do.
It's on page 13 of the direct testimony. That's PNM Exhibit 2 at line 4. In the question, it states 100 hours. It should say 150 hours. The 100 should be 150.
And Your Honor, if we could make that correction, or ask the court reporter to make that same correction in the pre-filed exhibit that will be part of the final record.
I think what we'll do is go ahead and let the record reflect that that change has been made. We already have, I requested in the procedure order that a mechanism for making corrections that required handwritten corrections on the document that was submitted on January, I guess on January 5 or January 6 to Dropbox. And so we'll go ahead and reflect that that correction has been made. I have a couple of others that possibly Mr. Phillips may want to make that should be reflected as well. May I ask the witness, Mr. Gifford?
Of course, Your Honor.
Thank you. Mr. Phillips, on page 4 of the direct testimony, line 25, should the date there be January 2022? Or is it, what's reflected there is January 2020?
Yes, sir, you are correct. That should be January 2022.
Okay, let's reflect that correction as well. And I have one more, and I'm not sure if it's in your.
Well, okay.
Well, go ahead.
Let's say the annual contractual cost would begin in January 2022. As I'd indicated earlier in the question, there's some initial program costs that would begin actually in January 2021, or as soon as the contract gets approved and has a final order. That's when those costs would start to be incurred for the equipment and the stand-up of the program.
Assuming approval, that would be the case, yes. Okay, well, with that clarification, that correction is made. The other that I spotted is in your rebuttal testimony. We'll get to that next. Okay, Mr. Gifford, go ahead.
Do you have any further corrections to your direct testimony, Mr. Phillips?
No, sir, I do not.
And do you have any corrections to your rebuttal testimony?
I did not catch any. I am about to be made aware of one.
Your Honor?
Thank you, Mr. Gifford. Mr. Phillips, on page 10 of the rebuttal testimony, line 5, you see the word perforce there.
Page 10, line 5.
Yes, sir. Better align the modeling assumptions with the expected performance of the DR resource.
Yes, sir, that should say performance.
Okay, that buzz, I guess, meant yes. All right, so that's the one, the only thing I noticed in that testimony, as well as what we talked about in the direct testimony. Mr. Gifford?
Thank you, Your Honor, and thank you for your superior copy editing skills as well. At this time, we would move
And
admission.
Mr. Gifford, I'm not trying to be a smart aleck. It's born out of extreme frustration because you've seen all my errata notices.
Understood, Your Honor. No, I'm horrified that we missed it. But at this time, Your Honor, we would move admission of PNM exhibits 2 and 3 as corrected on the record here.
Any objection to the admission of PNM exhibits 2 and 3? PNM exhibits 2 and 3 are admitted.
With that, Your Honor, we offer the witness for examination.
Thank you, Mr. Gifford. Is there anybody who would like to question or cross-examine Mr. Phillips besides myself? Anybody? Okay, then that leaves the questioning to me. Mr. Phillips, good morning.
Good morning.
I guess I'd start at the beginning, which goes back to the testimony that you noticed I wanted to admit it pursuant to administrative notice. And that is the testimony in the supplemental replacement resource case that started this, that precipitated this proceeding. The commission moved the consideration of the demand response proposal that we're addressing today to this new case. And in your direct testimony in this case, you say that, as I noted at the outset of my testimony, once ITRON studied the conditions and potential for DR on PNM system, it returned with the message that the full 24 megawatts of firm capacity was not available, but that it could achieve 15 megawatts. Now, my understanding from your earlier testimony is that ITRON had provided a bid for the full 24 megawatts. Is that correct?
Yes, sir, that is correct.
And when did it submit that bid?
The bids were submitted on September 14th of 2020, if I remember correctly.
September 24th?
24th.
And so that even shrinks the timeline further then. From September 24th until you filed the testimony in this case on September 28th, 2020, correct?
Yes, sir. Yes, sir. I apologize. The RFP bids, as were indicated on page 3 of that testimony referring to that was filed on September 28th, the RFP bids were received on September 14th of 2020.
That's fine.
Okay.
Well, 10 days.
Yes, sir.
So I acknowledge in your testimony that you talk about the factors that went into ITRON reducing the amount of firm capacity deliverable pursuant to the demand response proposal. But may I ask what really happened in those 10 days between the initial filing of the direct testimony in this case and what was it? No, you said November.
So we received the bids on September 14th.
I'm a little confused. I'm sorry. Excuse me for interrupting you, but I'm a little confused about the time sequence now. So go ahead and explain it for me.
Yes, sir. So we received the bids from the RFP that we had issued We received the bids on September 14th of 2020. The original bid submitted by Itron indicated that they thought they would be able to deliver 24 megawatts of primary resources and actually also 16 megawatts of secondary resources indicated in the RFP by summer of 2022. We started to review those bids with Itron and follow up with questions. And at the time of the September 28th testimony filing, there was no indication that the bid was going to change. Over the next approximately 30 days, we entered into non-disclosure agreements with Itron and provided them customer class level data, as well as non-customer specific data of the C&I customer groups that were participating in the Peak Saver program, as their bid was intending to target commercial industrial customers for this RFP response. On approximately October 28th, after reviewing that data, we had a call between Itron and PNM to review that data. And that was when the first time they revealed that they did not think they were going to be able to maintain the bid that they had submitted. We got a formal email from them with a revised scope then on October 30th, where they formally stated that they would no longer be able to maintain the 40 megawatts, the 24 and 16. And in fact, the best they thought they could do was 15 megawatts. It was also in that email where they indicated that in order to maintain that 15 megawatts, they were also going to need to reduce the hours of the program from the 400 down to the 150.
But they would preserve the no opt-out provision
Correct.
and the 10 minutes notice.
Correct.
Now, Itron runs one or both of the PNM's existing demand response programs. Is that correct?
They run the Power Saver program.
Who runs the Peak Saver program?
Imbala, formerly Internoc. The company now is called Imbala. They were formerly Internoc, I apologize, no T, and they were acquired by Imbala.
Could you spell that name out, please?
Imbala is E-N-B-A-L-A.
Could you tell me if Imbala provided a bid here to the RFP in this case?
I guess I question if that's confidential information.
That's why I asked if you could tell me, and if you want to maintain that confidentiality, that's I can find that through other means.
Okay, I believe the non-winning bidders information, names, and is confidential.
Correct. I'm not going to challenge that here. Well, the negotiations with Itron were going along. Were you communicating with were there any other bidders that you were still considering?
We focused
Those
our
bids?
I'm sorry. No, we had focused our bids, our negotiations on pursuing the contract with Itron at that point. We originally had thought Itron would be able to cover the full requirements of the RFP. And at that point in time, we had not continued any negotiations with other bidders. And again, it was not until October 30th that we had formally been notified by Itron for the need to reduce their bid.
Right. And Ms. Phillips, is it a common occurrence or practice of PNM to provide to receive RFP bids and then focus negotiations shortly thereafter with one of the particular bidders?
It's common practice once the winning bidder or bidders for a RFP have been selected to focus the negotiations on those winning bids.
Plural, you said, but in this case, it's one bid.
Yes, sir.
And I guess what you may know what I'm thinking about here. It's PNM's last case in the iteration of the replacement resources, where PNM entered into negotiations with one of the winning bidders and came up with a more inclusive proposal for the solar storage and battery storage projects, and proposed an alternative proposal that would have frozen out one of the other companies that had was a CCA one approved resource. Do you recall that?
Yes, sir, I do.
So I'm wondering, it just seems to me, I'm just observing that I just don't know how conventional it is for this to occur, where you have a bid for 24 megawatts. And I acknowledge the factors that you're saying caused the bid to be reduced substantially from that which was actually ordered by the commission. But again, it is given the experience in the last case, to see that come up here, that may have raised some eyebrows in certain quarters with regard to what was proposed. And reading between the lines of your direct testimony, I can sense some frustration. Is that fair?
Certainly there is some frustration. I would say, had we known of the bid being 15 megawatts at the outset rather than late in the game, we would have pursued negotiations with both bidders and seen where we could have gotten to.
Right. And I want to make clear that I'm not criticizing PNM for its approach necessarily. We'll see where the record takes us, but please don't take this as criticism. I understand it'll be clear from the testimony that that PNM has put forth strenuous efforts to attempt to comply with the commission's order. And I think that'll be clear as my dialogue with you and the other witnesses continues with regard to this. As I already said before we went on the record, this somewhat unconventional proposal, the way this is coming about. And what I mean by that, and as I explained before, is we'll see where the evidence takes us, but this is a demand response plan proposal that's being proposed outside the context of an Efficient Use of Energy Act plan docket, where demand response and DSM, demand side management programs and measures are proposed, scrutinized, evaluated, and either approved or disapproved. Does that make sense, Mr. Phillips?
Yes, sir, it does.
And in that regard, I'll just go ahead and ask now, since I may forget, have you been involved in the energy efficiency dockets?
I was involved in the energy efficiency plan filed earlier in 2020.
And that was for the 2021 plan?
Yes, sir.
Case number 20-0087 UT?
That sounds correct.
00087 UT. Are you aware, in your experience with PNM, and even before that with other utilities, to the extent you have experience there, have you had a proposal like this, which is being proposed for compliance with the Energy Transition Act, effectively? Had a demand response plan proposal reviewed outside the context of an EA type proceeding, energy efficiency proceeding?
Here at PNM, I am unaware of any demand response programs that have been reviewed outside the context of the EUEA. You may want to follow up with Mr. Johnson on his experience with PNM over a little bit longer period of time. Outside of PNM, while it's not specifically demand response programs per se, I am aware of a number of interruptible programs that are similar to demand response that are done outside of the context of efficient use of energy acts or similar legislation.
And now I'm looking at Mr. Gould because we're back to the interruptible credit option. Is that still, is that tariff still in effect, Mr. Phillips? I don't recall. The ICO?
The rate rider aid, the incremental interruptible rider. Is that the question?
Right.
Yes, I believe that rider is still in effect and will be the subject of inquiry in the next rate case when PNM files the next rate case.
Because it's inoperative.
The rider, yes, it needs to be reviewed to ensure that the interruptible rider would work as expected or is removed.
Because it's never worked.
Correct.
And so the question might be there, and I've raised this question again, is what's the appropriate docket for considering that new rider? Is it the rate case or would it be the Energy Efficiency Act? I don't know. That's really beside the point here, but again, it just goes to the fact that we're in a little bit of murky waters here with how we address demand response as opposed to supply side resources. Mr. Gould, I invoked your name. Go ahead. I think you might have to unmute yourself. Mr. Gould?
I'm unmuted according to my, yeah, hold on here.
We can hear you now.
Okay, sorry about that. This is why I need lots of help.
Thank you, Ms. Kaiser.
We can affirm that the rate rider rate is still in effect. We have 2 members in our organization that are in that rate, and it is our understanding that it was adopted as part of a general rate case, is one of those legacy rates that PNM has carried forward. And we would assume that this issue is going to be addressed in the next rate case. And matter of fact, that's kind of where we have. I don't know if that's an answer to your question. I don't want to get beyond the record here, but
no, my point is this is a sort of a new area and a complicated area, and I can see the reasons why the company might want to propose a revision to that rider, that rate in a rate case for various reasons. But juxtapose and contrast that with a demand response program like this, which in some respects may be indistinguishable from, in some respects, let me emphasize, from a peak saver type program, which is what there are similarities and differences, but let's leave it at that. But
well, if I could just
along, I think it'll become clear about where I'm trying to go with this. Go ahead.
If I could just state it would, the reason, and I, again, maybe I'm getting way too far afield, but rate rider aid acts as a credit, as you know, against the basic rate of the rate rider rate customers. So our belief is that if that rate is substantially changed, it's going to change the allocations, the basic cost allocations in the rate case as well. So you're right, it is very complicated, but without getting into too much legal argument, that would be our position on this matter. Thank you.
And why I engaged Mr. Gould on the issue is, as we go along dialogue, is before we went on the record, I addressed with the parties the appropriate legal standards to apply to the demand response plan and the proposal in this case. And one of the areas, and I'm going to ask Mr. Phillips now, is regarding whether a net public benefit analysis of the DR plan in this case, pursuant to Rule 551, would be an appropriate analysis or a required analysis, which may be an issue for legal briefing. That, among other issues, is what I've engaged already. And so with that, let me go back to Mr. Phillips. Mr. Phillips?
Yes, sir.
Are you familiar with the rule governing the prior approval of purchase power agreements?
I'm generally familiar with it, yes.
That rule defines purchase power agreements that are covered by the Act as those that, first off, meaning an agreement for purchase power agreement, an agreement for purchase of energy or capacity or both by an electric utility. Then a long-term purchase power agreement is one with a term of 5 years or more, for which an electric utility seeks or intends to seek rate recovery. Now, this is a long-term agreement, right? It's a 10-year term agreement, Mr. Phillips?
Yes, sir. It is 10 years.
And it's for the purchase of capacity?
So I would say it's for a product similar to capacity, but it's not for capacity itself. If we were to go to my exhibits, it's PNM Exhibit 3. That's the scope of work, or I'm sorry, statement of work at page 17 of, I'm sorry, PNM Exhibit 2, which is, I'm getting confused. It's
NLP 3?
3, yes. It's I guess my testimony is Exhibit 2. It's PNM Exhibit NLP 3 to Exhibit 2 at page 17. The most accurate description is found here, where we talk about it's under 1.1. It's a demand response resource that will deliver up to 15 megawatts of demand side management resources. And a little bit later in that sentence, in the form of firm summer load curtailments. So what this is, it's a product for services from customers that reduces the need for supply side capacity procurements. It's not capacity itself.
It's a surrogate for capacity.
Correct.
But in being a surrogate capacity, you're treating it as capacity.
It reduces our capacity requirements, so we need less capacity.
And if this plan, if the commission does not approve this plan, what will PNM be replacing it with?
In the short term, we would go to market and try to procure market purchases. Likely, ideally, it would be something unit contingent or a firm purchase starting about a year out to secure that capacity for the summer of 2022, similar to what was described in my direct testimony for the shortfall between the 15 megawatts presented here and the 24 megawatts. We would just increase that amount for the short term. And then to ensure reliability over the long term, we would propose longer term firm resources in the next round of procurements we would do, likely for the replacements of the Palo Verde leases.
And how would that coincide with the IRP and the energy efficiency plan proposals for 2023?
So the IRP will be filed later this month, and we will show what the long-term portfolio requirements would be. Now, if the 15 megawatts here were not approved, I will say the preliminary analysis for the IRP we have done so far has assumed the approval of this contract. So we would need to take a look at what would fill the void absent the approval of this contract. Looking forward into the 2023 energy efficiency plan, we would be reevaluating the contracts for Power Saver and Peak Saver to see if they would be continued beyond 2023 at that point in time.
Do those contracts expire in 2022?
When
do those contracts expire?
Okay, that would be, I would ask you to follow up with Mr. Johnson if possible on that, but I believe we asked in the energy efficiency plan for a 1-year extension through the end of 2023. So that way we can kind of time it with the next energy efficiency filing.
All right. And I have that to take up with them. Thank you. So with regard to the issue, going back to the issue of what would replace the proposed DR plan if the commission does not approve it, you're talking about shorter term market purchases, firm purchases of capacity and energy, just energy or capacity or both?
It would be short-term capacity and energy, a firm energy purchase. So it would be the couple.
Have you done any analysis of that contingency that the commission does not approve this proposal, this DR proposal?
No, we have not studied that to determine what. We believe that we would be able to go out and secure in about a year ahead purchase, secure that capacity and energy. We have not probed the market yet to determine what the price of that would be. Typically, it's about a year out where you start looking at those firm deliverables to obtain the best price.
Would it be prudent to do that contingency planning now, given that I don't know, I obviously, I'm nowhere near making up my mind on whether I can recommend approval or not. I may recommend approval, I may not recommend approval, I don't know. And even if I do recommend approval, the commission may approve the proposal or it may not. But that being the case, and being the case in every docket that I have potentially, that contingency planning, a study of resources that might be available, would that be a prudent thing for the company to do now?
Certainly, we will be continually looking at those type of issues going forward. We keep our eyes on forward markets. Typical forward pricing for delivery of the summer of 2022 right now is in the neighborhood of about $100 per megawatt hour. The ability to obtain that is going to be explored as we get towards the summer of this year. We certainly can look at that much more closely in a larger amount.
Now that I broached the issue, and even if I hadn't, the commission might ask, well, what is PNM going to do if we don't approve this? And we need to know what the impact on the ratepayer may be. Would this 15 megawatts of DR be a better deal for the ratepayers than what might be available otherwise? Give all factors considered in this docket. So would you be prepared to put together some sort of study and provide it as in response to a bench request?
Certainly, if we were asked to do that, we would provide it. I would ask for a couple of clarifying questions if you would like that analysis.
I would. Go ahead.
So would the assumption be, what is the alternative for the 15 megawatts strictly for market purchases, or is the alternative a short-term market purchase to cover summer of 2022 and then a longer-term procurement that could come online, say in summer of 2023 and beyond?
Or pursuant to an RFP for a revised DR plan, is that what you're saying?
Or any type of resource. I mean, what we would intend to do likely is purchase short-term capacity and energy from the market, and then procure a long-term resource through either We did an RFP that was issued in June 24th, I believe, of 2020 for replacement capacity and energy for the Palo Verde leases. And we could explore expanding the replacements there to cover this shortfall, or as well as we are.
I think in the alternative, you find amenable in the alternative, Mr. Reynolds' recommendation regarding evaluating other alternatives, because as you know, staff is recommending rejection of the proposal in this case. So with that recommendation in mind, does that address the question?
I think so. I guess I would like to just clarify one more piece then. My understanding of Mr. Reynolds' recommendation is to deny the application in this case and consider everything holistically when we look at the energy efficiency programs under the EUEA. If we were to follow that path and reserve this spot specifically for demand response, we would then want to look at market purchases for a few years, not just 1 year.
Okay, let's do that then.
Yes, sir.
Thank you. Okay, that's the first bench request to PNM. And we'll discuss at the end of the hearing the timing for filing of the response and any replies to the bench request response pursuant to the Commission's rules of evidence. We'll call that the alternative resources. Evaluation or study. Now, along those lines, Mr. Phillips, do you have Mr. Reynolds' testimony?
Yes, I do.
Could you please turn to his attachment JJR-2 to his testimony? It's a table containing the CCA1 portfolio elements.
Yes, sir, I'm with you.
Okay. Now, the total amount of generation and storage in CCAE1 that we focused on is 950 megawatts, right?
Yes, sir, that's correct.
And the demand response portion is 24 megawatts, and that's what we focused on in the recommended decision. You also have coincident peak adds of 16 megawatts, and you call those the secondary resources, right?
Yes, sir.
What does those consist of, the secondary resources?
In CCAE's portfolio, along with the generation and storage resources and demand response, they had also assumed some acceleration of energy efficiency measures. And for the deliverable time, that ended up being incrementally 16 megawatts of peak reductions associated with those energy efficiency measures.
And I'm gonna cross-reference you here too. Now I may get a little confusing, but I don't want to forget this. Do you also have Mr. Brandt's testimony?
Yes, I do.
In his testimony, he indicates on page 6 that due to implementation of energy efficiency programs in case 20-00087-UT, PNM now forecasts 20 megawatts per year of incremental system coincident peak reductions for years 2021 to 2023, exceeding PNM's and my forecasts. And he cites there to attachment JB-2, PNM response to CCAE interrogatory 2-2A. And you were the respondent to that interrogatory, right?
Yes, sir, I was.
Is the estimate that Is that estimate, that former estimate, 16 megawatts?
In the modeling assumptions during the 195 docket, the energy efficiency forecast assumed 10.6 megawatts per year of coincident peak demand reductions. Mr. Brandt had increased that as a part of the CCA1 portfolio. It was that incremental value above the 10.6 per year that equates to the 16 megawatts of reductions by the time we got to summer of 2022.
And reading your testimony, now the estimate there for forecasted incremental system coincident peak demand reductions for the programs approved in the last energy efficiency case are now 20 megawatts per year. Do you stand by that response, or do you question that estimate, that forecast now?
The 20 megawatts for the program?
Yes.
That is still the best estimate for the current proposed energy efficiency program that was filed last year.
And I guess, am I confusing that with the concerns over the performance and the ability to meet the cost-effective tests of the Peak Saver and Power Saver programs? Am I confusing that? Because at certain points, you point out that there have been some deficiencies there. If that deficiencies may not be the right word, but the performance has not been, the performance has slowed down, if you will, for those programs. Am I confusing things?
I'm not sure, but maybe I can say what I'm thinking. The 20 megawatts that Mr. Brandt references for the energy efficiency program measures is specifically the energy efficiency measures, not including Peak Saver and Power Saver. Those are ahead of what was forecasted in the San Juan case. The performance of the demand response programs under the EUA, Peak Saver and Power Saver are below what was forecasted in the San Juan case.
Okay, great. Thank you, Mr. Phillips. Okay, let's go back to Mr. Reynolds' exhibit JJR-2. The proposal in this case for 15 megawatts is not for conventional generation or storage. It's a surrogate for capacity. And it's a relatively small amount, 15 megawatts. So I guess I'd like you to try and put some context around this figure, particularly in terms of the overall CCIE1 portfolio, for the amount of generation and storage replacing the abandoned San Juan resource. How consequential or impactful would the non-approval or the absence of this 15 megawatts from the portfolio be to the company and the company's customers from a reliability standpoint, from a demand standpoint, and from the ratepayer perspective? And you could see how, I should note, this ties back into the bench request, that the first bench request with regard to comparing the alternative in the absence of these 15 megawatts of demand resources if the commission doesn't approve them. How impactful would it be to the company's operations in terms of reliability, systems management, and impact on ratepayers?
Certainly, we would be concerned about the reliability aspect. So of course, that was of a great concern during the 195 proceeding, and I don't want to rehash that here. If I look at what we would consider the capacity provided by just the generation and storage portions of the portfolio listed on Mr. Reynolds' exhibits, for firm planning purposes, that 650 megawatts of solar generation is only going to contribute approximately 16% of that nameplate value towards our firm capacity. At least that's what the ELCC study that we had conducted as a part of our current IRP process would show, is that inclusive of all of the solar that is currently on the system, plus what is proposed in the CCAE portfolio, the effective firm capacity of that solar fleet is going to be approximately 16.7%. So eyeballing it, that's a little over 100 megawatts or so off of the 650, maybe it's 120. The storage resources will contribute, about 96% of that 300 megawatts towards our firm capacity needs. So we're sitting there between those generation and storage resources at a little over 400 megawatts relative to the 500 megawatts of San Juan capacity that's coming out. So we certainly are going to be concerned with the reliability of the system, and we'll need to be probing the market to make sure that we have adequate supply to serve our customers. The demand response and the energy efficiency additions would contribute towards that reliability requirement.
But and your bench request response, you'll provide us an alternative, I'm assuming.
Yes, sir.
So again, I'll go back to just a general understanding of the issue. How impactful will it be? For instance, let me go back. You cite our colloquy in back in January 2020 in 19195, where we discussed demand response. And sort of the theme that I've come up with here is, are we dealing with, in this DR proposal in this case, sort of trying to jam a square peg into a round hole? And so if hearing examiner Shenar and I had recommended that the CCA1 portfolio be approved, and the commission approved it for 950 megawatts without the demand response component, the 40 megawatts or the 24 megawatts, what would the company's reaction had been to that? If we had left out, because there was some consideration of how do we address this DR proposal. We're gonna, clearly in the recommended decision, we said, we're going to have you address it separately. One of the alternatives, and the first alternative, was to go ahead and propose a modification to your energy efficiency, the 2021 plan, in case number 2087 UT, right?
Yes, sir.
Okay. So if the recommendation had been, and it's just hypothetical, commission approved the 950 megawatts of generation and storage and deal with the demand response proposal somehow separately, but don't necessarily require a proposal for a replacement resource with regard to that smaller component, how would the company have reacted in that instance?
I think we would have reacted similar to what's proposed for the shortfall in my testimony between the 15 and the 24. We believe that there's going to be some capacity deficiencies, and we will need to probe the market regardless of whether the DR proposal is there, and do our best to ensure that we're going to have adequate supply for the summer of 2022. And through the additional procurements going forward that will be identified in the IRP, the Palo Verde replacements, and eventually the Four Corners replacements that we've talked about in publicly, we would propose additional capacity and energy resources through those replacement cases.
And could you be relatively as specific as you can be about the types of resources in your evaluation and your study that I requested? Not with respect to the specific resources, but the types of resources. available to the company?
So for the integrated resource plan, we are focusing on wind, solar, batteries, combustion turbines, demand response. We had some RFI responses that had some other forms of storage that are not offered into our current RFP that we're evaluating. So when we compare the resources then that we were looking at generically in the IRP versus what we received in response to our 2020 RFP that will serve as the basis for the Palo Verde replacements, it's mainly peaking gas units, well, we did not get any demand response bids in that RFP, solar, wind, and battery storage.
And okay, so I guess I'm asking you that in the evaluation to identify the types of resources that you'd be looking at and attempting to put prices or costs with those particular resources, types of resources.
I can do that.
Is that feasible?
Yes, it is.
Thank you. And you mentioned a rough figure of what, $100 a megawatt hour?
Yes. In looking at forward markets right now for delivery in summer of 2022, that's a figure that you would see for delivery. Did my Zoom just freeze up?
No, you're here, but I noticed that you looked up to your right. Is there somebody in the room with you?
A person just walked by my office. The door's closed though. Yes, the current forward markets are showing approximately $100 per megawatt hour for delivery in summer of 2022. That's a very ballparkish number, just looking at publicly available numbers. We would want to go and do a more specific procurement or a survey of the market by reaching out to prospective suppliers.
And how does that compare to your estimate of the $112 per kilowatt per year for the DR proposal? Is there any way you can put meaning around that to do as close to an apples to apples comparison of available alternative resources?
Yes. Ballparking it.
And that's all I'm asking for, obviously. I'm not committing you to any particular figures at this point, or candidly in the bench request response either.
I would say subject to check, I'd want to do this, but if we were to take as an example the DR program contractual cost of $112 per kW year at the 15 megawatts, that's 1.68 million per year. If that is callable for 150 hours at that 15 megawatts, let me grab a calculator here. If I've done the math right, again, subject to check, we're going to be approximately $700-ish per megawatt hour for the DR program. However, I would just caution that when we're talking about a long-term firm product versus a short-term energy market purchase, it's not the best comparison, but if you wanted to compare it that way, you could.
It's not the best comparison, but you could. So we're talking about it'd be substantially more expensive. And I understand what you're saying.
If I was going to go to market now and ask for a 10-year product as opposed to a short-term product, I would have a higher price.
Good point, but you also might have potentially according to Mr. Reynolds' testimony at least, a better, more holistic approach to demand response that could be evaluated in the next plan docket pursuant to the RFP that you would be issuing, that might address some of the concerns that have been expressed by Mr. Reynolds and Mr. Brandt. Isn't that also possible?
That is also possible, and I don't disagree with Mr. Reynolds' thoughts on this matter. I think that the DR that we have proposed in this filing is a firmer, better form of DR than what's currently on our system. I certainly do see the logic in Mr. Reynolds' proposal as well.
I'd like to, right now, while I have it up, and another part of Mr. Reynolds' analysis is regarding what he considers, looking at the specific contractual provisions, whether the effective capacity commitment is actually less than the nominal 15 megawatts of capacity. And according to his calculations, based on your testimony, the effective capacity is 13.5 megawatts. I noticed that you didn't address that in your rebuttal testimony. I'm asking you to address that now. Do you agree or disagree with Mr. Reynolds' assessment?
I think that that's a way that you can look at it. Itron would be delivering 15 megawatts contractually. The penalties start to kick in when they fall below the 13 and a half.
Okay, let's look at those. Can we look at those penalty provisions?
Yes,
I think,
sir.
is it section 7.1?
Yes, sir, that's correct.
Let me get there. We're talking about section 7.1 of the statement of work. It's exhibit NLP3, correct?
Yes, sir. It's a PNM exhibit NLP3. It's page 27 of 36 of that exhibit.
Or page 14 of 23 of the contract of the agreement.
Yes, sir.
And it's entitled Summer Conditions of Default. And so there are approximately 4 conditions of default there enumerated. Is that right?
It's just contained in section 7.1. Yes, there's other conditions default in other sections of the contract.
Okay.
Yes.
But these are the ones that we're focusing on for the total amount deliverable.
Yes, that's correct. Once the program has been initiated and demonstrated that it can deliver, then these are the main conditions of default that would be in effect.
Looking at these conditions, is it possible that Itrons could be required to deliver actually less than 90%? Or is that first provision, does that govern the basic amount, the baseline amount that Itron contractually is bound to deliver, the 90%?
Let me make sure I understand your question so I'm as responsive as I can be.
Can I amplify a little bit?
Yes, sir.
For instance, the second provision says that performance for an event with a duration of 1 hour will be reviewed separately and will be based on the demand reduction in that hour. And if that 1 hour event fails to achieve 82.5% of the expected demand reduction relative to the contracted capacity in section 3 of the CNI program, SOW. That contracted capacity in section 3 is the 15 megawatts, correct?
Yes, sir, that's correct.
So 82.5% of 15 megawatts is obviously lower than 90%.
Yes, sir. That provision came about after looking at what previously was provision 2 and is now is provision 3 which talks about if there's a single hour, it falls below 75%. Now, what we started talking about with Itron was, well, if you've got a multiple event hour and you're at 90% in 1 hour and you fall below the 75% in the next hour, if we talk about a single hour event, then that's where the 82.5 came from. But I understand your point. Another potential would be if you look at the number of strikes or misses that you would. It says there's 4. You've got to have 4 misses of the average event duration, or of 90%. So it would be perceivable to think that if you had only 3 events called in a year, they could come in at say 88% for 3 events. That's less than 90, and that would still be within compliance.
Okay, well, how low can we go and still be in compliance then? Because we're now reducing it potentially below 90%. So a 15 megawatt product becomes, and potentially becomes a 13.5 megawatt or 13 megawatt product. The commission's going to ask me this.
Right. Please bear with me. I just want to reread this one more time.
Yes, thank you. Take your time.
If we were to assume a worst case scenario, by my reread of the contract and remembering what we looked at, if you were to have, taking into consideration sections or bullets I, 2 or 1, 2, and 3, if you were to have less than 4 events called in a season, but greater than 2 events, so you have 3 events essentially, there could be a possibility that as long as all hours in those 3 events were above 75%, that would still technically not be in default. Similarly, if you had only...
So, and what would the, Mr. Phillips, what would the baseline performance criterion then be in that particular instance? Would it be 75%?
It would be 75%. It would be the worst case scenario with 3 events. So
that's worst case scenario from the company's perspective, perhaps, or from energy efficiency aficionados, but not necessarily Itron, because under this agreement, does Itron have any incentive? It gets full payment, right?
there are financial penalties.
But those financial penalties kick in for default, not for not. This is, they're not in default if they.
There are other financial penalties contained within the contract at section 7.4.5.
Okay.
And so,
yeah, and that I wanted to go to that because that was potentially one of the numbers, because it says if it falls below 80%, between obviously between 75% and 90%. If it falls below 80%, so is 80% the operative number for performance?
I really don't.
Not 90%.
I really don't think it is. I think the 90%, I mean, there are situations where they could fall below 90% and not be in default. But when we looked at the way we would anticipate this program to operate, the number of events that would be called based on our modeling, it's highly unlikely that you would have situations where you'd only have, you know, 1 or 2 events called per season. And so the chances of being in a situation where they could fall that far below is unlikely.
Fair enough. But we're speaking in terms of contractual agreements and what would be approved and what Itron would be expected to deliver. And at most, they're expected to, well, at their baseline delivery in order to receive the payment of $1.68 million per year for the 10 years of the contract is to deliver 13.5 megawatts. Is that correct?
Correct. Under the, there is the 10% threshold before they would hit strikes. Yes.
Okay, so that's not their worst case scenario. That's just their target, not 15 megawatts, but 13.5. But there are situations though where it could fall below, right?
Yes, sir. I guess my concern would be is if they intended to only deliver 13.5 megawatts and not 15, that would be bad faith negotiations.
But that's not that. It might be crafty contractual drafting though.
Point well taken.
You negotiated separately with this particular bidder, and they came. This is the language that is being presented to the commission to approve, and as represented, the nominal 15 megawatts is actually at best 13.5 megawatts, correct? Mr. Phillips?
Yes, sir. I disagree with the saying at best. I fully believe that Itron is going to try to deliver the product that they have agreed to, which is 15 megawatts.
Is there any pecuniary incentive for them to do so?
I don't know what pecuniary means. I'm sorry.
Remunerative, any monetary incentive.
Any monetary incentive? No, sir, there is not.
And that's what makes the world go round, right?
Yes, sir.
That leads to the next point about that Mr. Reynolds makes. The next step in his analysis of this is assuming those numbers are accurate. And I'm not sure yet whether we're there yet. And it may be a requirement for briefing the analysis of that section and how that works, and whether indeed, or whether it'd be more appropriate to have a bench request response analysis. And we'll see where this goes with regard to what actually is the baseline deliverable there, whether it's 13.5 megawatts or whether it's actually something lower than that. But it be that as it may, looking at first JJR3 through Mr. Reynolds' testimony, he does an analysis of the nominal cost per year that first, accepting, I believe, the company's numbers, he adds the initial setup. He comes up with, Mr. Reynolds comes up with the cost per kilowatt nominal on JJR3 of $118.23. Do you question that analysis? Or do you think that's accurate?
I don't dispute if you roll in the upfront costs and divide by the total number of kilowatts that you come up with that number.
So that is a total contractual cost per kilowatt.
Including the upfront.
Nominally.
Yes.
assuming 15 megawatts?
Yes, sir, that's correct.
Right. But then next on JJR4, assuming 13.5 megawatts or 13,500 kilowatts, as shown on JJR4, the effective cost per kilowatt becomes $131.36. Do you have any reason to dispute Mr. Reynolds' analysis or conclusion?
No, if you discount the program to 13.5 megawatts per year, that would be the effective cost.
And we've already discounted the program to at least 13.5 megawatts per year, correct?
I
In our
understand.
colloquy, we've already agreed that that's the amount.
I understand that your point is there's no monetary damages to or incentives for Itron to go above the 13 and a half. I still think that their intention is to deliver the 15 megawatts.
And I have no reason to doubt their intentions. All I can look at is the black and white print
Yes, sir.
and what the commission would be asked to approve. And it would be effectively a 13.5 megawatt program of firm capacity, not 15 megawatts.
I can understand that perspective. For that same perspective, we would have a very much different picture of solar and battery storage and every resource when we start looking at the effective capacity than not the nameplate.
Looking back at Itron's performance under it's the Power Saver program that they run, right? That
Yes, sir.
company runs. I guess that's the next question. You know where I'm going with this is, how have they performed under that contract?
That contract, I believe, Mr. Brandt attached a response of mine to his testimony. If we and then the same is found on the figure in, I believe it's figure 1 in my rebuttal. We can see that the both programs under the EUEA are decreasing in the effective capacity that we provide. But if you were to look at Mr. Brandt's testimony, it's his exhibit JB2. There's a response that I responded to, CCA interrogatory 1-8. We show there that the Power Saver program, effectively based on the enrolled megawatts and the total cost of the program versus what the average hourly deliveries were for 2019 and 2020, was approaching $212 per kW year.
And he does that analysis. But in terms of Itron's performance of the program, has it been meeting its deliverables targets under that contract? Do you know?
It'd be a better question for Mr. Johnson. I believe their contractual requirements is 25 megawatts, but we would want to follow up with him.
I guess I'll ask that trust but verify question to Mr. Johnson then, if I remember to. But I guess that brings into question, it's a fair question to ask him about how Itron is performing under an existing contract, where here, based on good faith, you're expecting them to provide 15 megawatts. Is that fair?
Yes, sir.
Okay, so to recap, when you don't dispute Mr. Reynolds' analysis that at best now, with 13.5 megawatts, that the cost per kilowatt effectively for the program proposed here is actually estimated to be approximately $131 per kilowatt per year.
I don't dispute Mr. Reynolds' math. I still believe that
The math is accurate
Yes, sir.
and the analysis is fair or cogent.
I can understand the perspective. Again, my true belief, sir, is that Itron intends to deliver the 15 megawatts. I can understand the point of view that Mr. Reynolds and yourself are taking, that the 13.5 is another way to look at this.
Well, I'm not taking a point, I'm taking evidence. I may read the transcript and look at the evidence and say, wait, I was off there. It actually is some other number, right? So I'm not making a point. I'm a fact finder here.
I can understand the way that you can look at this is that Itron is not obligated to deliver more than 13.5 megawatts without penalties.
They are not, in fact, they are not obligated under this contract to provide more than 13.5 megawatts.
Without facing financial penalties, that's correct.
And the company has already picked all the low-hanging fruit, right?
That's correct.
Speaking of fruit, what are the customer, is this the best asked to you? What customer classes are, what C&I, commercial and industrial customer classes are eligible to participate, would be eligible to participate in this program?
I believe it'd be a better question for Mr. Johnson. There's a discovery response attached again to Mr. Brandt's testimony that Mr. Johnson and I co-sponsored that lists the eligible customers. And essentially it's rate schedules 3B, 3C, 3D, 3E, 4B, 5B, 11B, 15B, 17B, 23, and 30B.
And what are you reading from?
Oh,
I don't see that attached to his testimony.
I apologize. Please disregard that. That's who's eligible to participate in Peak Saver.
Right, I saw that. Would it be the same customer classes?
It would be the same, I believe. Let's follow up with Mr. Johnson.
Okay. We've been going for a while. Ms. Phillips, would you like a break?
I'm able to keep going if you are, sir.
Okay, let's go on a little bit longer. I still have quite a bit for you. Just go about 5 more minutes and then we may have to take a break. If for no one else, certainly for our court reporter. Cost effectiveness. We talk a lot, and Mr. Johnson does about, and Mr. Brandt, about the cost effectiveness of the program. Now, when you use the term cost effective, what do you mean?
In the
Define
context,
cost effective. I'm sorry, excuse me. Sorry for speaking over you.
no. Cost effective. I would define cost effective as being, part of a, portfolio of resources that meets, certain cost thresholds. When the commission approved the CCA1 portfolio, there was an expectation of what the costs would be as a part of that portfolio. And we had an idea of what some of the other resource costs were that were not included in that portfolio. When I talk about cost effective in the context of my testimony, I was looking at the assumptions that were utilized in the CCA1 portfolio, what the cost of the Itron contract was, and thinking, well, what would be the next least cost resource that could come in?
And in fact, you analogize this resource at what we've now agreed is basically a cost per kilowatt effectively of $131 roughly to the battery storage projects approved in the last case, right?
Yes, I compared the cost of the contract to the 4 storage resources that were also included in the CCA1 portfolio.
And the parameters bounding that are roughly one battery storage project is at approximately $120 per kilowatt at the high end, and the low end about $90 per kilowatt per year. Is that right?
Let me find it in my testimony, but that sounds correct.
And what I did while you're looking that up is I looked at the contract prices there. Hickory Storage Project is at $9.97 a kilowatt per month. I multiplied that by 12 months to reach the total $119.96 per kilowatt per year on the high end. And then on the low end is the Arroyo Battery Storage Project at $7.46 per kilowatt per month. Multiplied by 12 results in $89.52 per kilowatt per year.
Yes, sir. And that was also, I believe, in my September 28th testimony at the top of page 11. I had used the $112 per kW year from the ITRON contract and said that's kind of in the midpoint. I guess one of my points earlier I made was if we're going to discount the ITRON contract due to the contractual provisions, there's also provisions for availability guarantees, forced outages, and the effective load carrying capabilities that you may want to consider as a part of the energy storage agreements.
Yeah, and you analogized the demand response proposal here effectively to the battery storage projects, right?
Yes, sir.
Are you suggesting that the battery storage projects are more risky from a reliability standpoint than the DR proposal?
No, sir, I'm not suggesting that.
Would it be possible that in the evaluation of resources that you provide pursuant to bench request number 1, that this program could be substituted in whole or part with another battery storage project?
Is it possible that the DR program could be substituted by a energy storage project?
Yes.
Yes, sir.
And an energy storage project that comes in substantially below $131 per kilowatt per year.
Based on the costs that I've seen, in order for a energy storage project to come in under that, it would need to be paired with a solar project for tax credit purposes.
Fair enough. That's good information to know. Okay, let's take a 10-minute break, and then I have a few more questions for Mr. Phillips, I believe. We'll be off now until approximately, let's say 10 after the hour. We're back at 12:10.
Yes, sir.
Thank you all. We're in recess until 12:10. Thank you all. All right. Allison, you ready? All right, thank you. All right, we're back on the record with further questioning by me of Mr. Phillips. Mr. Phillips, I'd like to turn your attention to your rebuttal testimony.
Yes, sir.
And starting around page 2, regarding your response to CCA's view that PNM did not do what was required from case number 19-00195-UT. I want to preface my questioning in this regard with emphasizing that I am in no way faulting PNM for trying to achieve surety and reliability objectives and doing what it thought was necessary and appropriate. So please don't take anything that any part of my question as questioning any of that or imputing PNM or his motives. That's not my intent. That's not my that's not what I'm thinking here. But I guess it goes back to more of the concept of the square peg in a round hole concept of what we're trying to achieve here, if that makes sense.
Yes, sir.
Because, for instance, on page on page 6, in talking about some of Mr. Brandt's criticisms, you note that he criticizes PNM's RFP for not allowing customers to opt out of called DR events, right?
Yes, sir.
But you note that that's the exact phenomenon that has reduced the capacity value of PNM's existing programs. And I'll talk to Mr. Johnson in a bit about those existing programs, but for our purposes, the square peg and round hole concept is that this is an ETA born, or it evolves out of an ETA proceeding where you're attempting to achieve numerous objectives, including a strong emphasis on reliability. And sorry, my printer's going here. Somebody's printing. Sorry about that noise. But can you hear me okay, Mr. Phillips?
I can. I could not hear any printer.
Okay, good. My noise cancellation is working there. It was a distraction nevertheless. But In any event, as it so happens, you're trying to achieve certain objectives that you wouldn't ordinarily achieve or attempt to achieve, like energy savings with a typical DR program. Is that fair?
I might have lost you. So you don't try to achieve energy savings from a demand response program. Is that the question?
No, the objective, typically an objective of a demand response program, it isn't necessarily to be a surrogate for capacity for a surrogate for a firm dispatchable resource, right?
There are many different ways you could look at demand response, and typically the ones under the existing programs were not set up in that way to be firm capacity resources or surrogate for capacity resources.
What are their objectives?
And I would like to ask you follow up with Mr. Johnson on this a bit more. My understanding of those programs is they were set up to be as flexible as possible to increase customer participation and add to the energy savings and spending requirements under the Efficient Use of Energy Act.
And the cost effectiveness of those programs is evaluated under a different test than what we're talking about here. We're considering here, right?
Yes, sir.
The UCT.
Yes, sir. That's correct.
Are you aware of any other DR programs out there that do not allow customers to opt out of events, of called DR events?
Many of the demand response products that are offered through organized markets such as MISO or PJM, if you are offering yourself in as a demand response resource, you have to perform, or you will not be allowed to participate in the future.
As a customer.
Correct.
Now, I've been asking you about the EU EA criteria. And the reason I think that's fair is you addressed that in both testimonies, but most particularly in your rebuttal testimony in response to Mr. Reynolds' testimony. And in terms of asserting that, and again, this sort of goes to this theme of the square peg in the round hole, that the resources here, and I'm quoting your testimony on page 14 on to page 15, the resources here were ordered as part of the final orders SJGS replacement portfolio and not evaluated under the EUEA's criteria. It would change the nature and the extent of the energy efficiency plan analysis if the commission retroactively made the proposed DR resource subject to the EUEA. Do you think that Mr. Reynolds is proposing that the plan be retroactively changed?
I'm not sure. I know that he wanted to see a more holistic look in the context of the EUEA programs and when those contracts would be reevaluated. I guess my answer is I'm not sure.
But you agree that going forward, the next sentence, I think, is I see you as agreeing that for any new DR proposals, they should be part of the demand response programs included in PNM's EUEA portfolio, that has merit and should be given consideration by the commission. Is that accurate?
Yes, sir, that's accurate. I think what he has proposed is it should be given consideration, as I stated.
But this program should be treated differently.
Well, if I might clarify just a touch.
Please.
This program being ordered as a part of the replacement resource portfolio from San Juan, it's a system resource. And if we look at how the cost recovery for the Efficient Use of Energy Act works, not all customer classes pay the EE rider, and some customer classes have capped contributions to the EE rider. And so those customers who either are exempt or have capped contributions could end up getting many of some of their service requirements paid for without a full contribution towards the costs.
Let me go back. You're talking about subsidization?
In a sense, yes.
In the sense that there are certain customers that are exempt from the EER rider or are capped?
Right. Since we're replacing a resource that is paid for by all customers through base rates and provides capacity requirements and energy requirements for all customers, if you were to then put a replacement of that and have it only paid for in part or not at all by a certain subset of customers, there would be some subsidization going on.
Then the question becomes, what are they paying for in full or part, right?
Right.
And might it be better if this resource isn't included as a system resource at all? Perhaps maybe it shouldn't even have been recommended in this context.
I don't know that I would go that far. This resource, there is a place for demand response in the portfolio, and especially as we go forward towards our high renewable and carbon-free system, we're going to need price-sensitive demand. Right now, it could be that we need to look at, as Mr. Reynolds suggested, a holistic view of the programs and not look at things in isolation.
Now you've added subsidization to the equation.
Yes,
wow. Sir. Well, I'll address the EA criteria further with Mr. Johnson. But outside of that, I think, although I'd like for you to stick around for the balance of the hearing, if you could, Mr. Phillips, I think that includes my questioning of you for now. Would you be available for the remainder of the hearing?
Of course.
Thank you, sir. Okay, would anybody like to follow up with Mr. Phillips? I'll give a quick opportunity to anybody. Any redirect, Mr. Gifford?
Yes, Your Honor, just one clarifying question that I think may help fill out the record. Mr. Phillips, the hearing examiner was asking you about the provisions of the statement of work with ITRON and how the performance and penalty provisions work. Could you give the hearing examiner and the parties a description of how those terms and conditions came about?
Yes, sir. So when we were setting up and negotiating the contract to get to what is presented in front of the commission today, what I'll use as the term bandwidth, the 90%, the 13.5 versus the 15%, that's came apart because this still is a program that, unlike a dispatchable machine, is governed by human participation and human performance. Even if you say you can't opt out, that doesn't prevent somebody from just saying, I no longer want to be in this program, and is ITRON able to go back and backfill that spot in its portfolio to make sure it can meet its requirements. Similarly, in terms of the trade-off between those performance requirements and the liquidated damages provisions under default, one of the considerations was that a large portion of the contractual payments under this program will not be kept by ITRON, but would be paid to customers for their participation. And so in terms of setting the liquidated damages provisions, we had to take into consideration what was really being kept by ITRON versus what was going to customers.
Thank you, Mr. Phillips. No further questions.
Mr. Gifford, may I follow up?
Of course, Your Honor.
Thank you. That explanation does not change basic fact that at most the deliverable amount of capacity, or the capacity surrogate, is 13.5 megawatts at best, correct?
No, sir, it does not change that.
Okay, for now, Mr. Phillips, I'm sorry, go ahead. Is there somebody else? Was that
No,
you, Mr.
I was just saying nothing further from me, Your Honor.
Thank you, sir. Okay, thank you, Mr. Phillips. You're excused for now, but please hang around if you could.
I will be here.
Thank you, sir.
Thank
Appreciate
you.
your testimony as always.
Thank you,
All
sir.
right, PNM, would you please call your next witness?
Yeah, Mr. German will be doing that, I believe, Your Honor.
Yes. So PNM calls Zach Johnson.
Mr. Johnson, would you raise your right hand for me, sir? Do you solemnly swear or affirm the testimony you're about to give should be the truth, the whole truth, and nothing but the truth? Unmute yourself, sir.
I do, yes.
Thank you.
Mr. Johnson, can you state your name for the record and tell us what your position is at PNM?
My name is Zachary R. Johnson, and I'm the manager of the Energy Efficiency Group at PNM.
Great. And can you identify PNM Exhibit 4?
Yes, I can.
And is PNM Exhibit 4 your direct testimony?
Yes, it is.
Is the direct testimony prepared by you or at your direction?
Yes, it was.
Is it true and correct to the best of your knowledge?
Yes.
Do you have any corrections that you would like to make to the direct testimony?
I do not at this time.
Great. If the questions that were asked of you in the direct testimony were asked of you here today, would your answers be the same?
Yes.
So, Mr. Hearing Examiner, I will move the admission of PNM Exhibit 4, which is the direct testimony of Zachary Johnson.
Is there any objection? PNM Exhibit 4 is admitted.
And I will pass the witness for cross-examination.
Thank you, Mr. German. Is there anybody on the Zoom hearing that would like to question Mr. Johnson besides myself? Okay. Good afternoon, Mr. Johnson.
Good afternoon, sir.
How long have you been with PNM?
I have been with PNM almost 11 years now.
And how much of that time have you spent working on energy efficiency issues?
I joined the Energy Efficiency Group in April of 2019, so almost 2 years now.
I'd like to ask you first some questions about the Peak Saver and Power Saver programs. Were you here? I believe you were, for my questioning of Mr. Phillips regarding those programs.
Yes,
and
sir.
His testimony, I'm sorry, and his testimony in general?
Yes, I was present.
And forgive me for stepping on your answer. Regarding Peak Saver and Power Saver, how long will those programs remain in effect? When do they expire?
The programs were initiated in 18 with the original contract terms to expire in 2022. However, in our most recent EE filing and final order, we did receive approval to extend both of those programs through 2023 to allow and align with our next EE filing.
So they started in 2018?
Yes, sir.
The current contracts?
The current contracts, yes.
But those programs were in effect in an earlier iteration, one or both of them?
I believe demand response became part of the energy efficiency portfolio for PNM around 2008.
And were those similar or same to the programs that are in effect now in 2008?
I believe they were similar, but there have been modifications over time.
In their, starting in 2018, how have the programs performed compared to the earlier iterations of the demand response programs approved in 2008 going forward?
I have not done that analysis of performance from 2008 to 17, and then from 18 on.
You have not done it from 18 on though, or have you?
We've done M&V reports and annual filings every year, but I have not compared the first 10 years of the program to the last 5.
And Itron is responsible for the Power Saver program. That's the program for residential and small power customers, correct?
Yes, sir, that is accurate.
And that's an air conditioner related program?
Correct.
Are devices installed on participants' air conditioners?
Devices can either be installed on participant air conditioners, or we also have a wireless thermostat option as well.
And so it's sort of like, but it's not an advanced meter.
No, sir, it is not an advanced meter.
It's just a device devoted to the air conditioner, like any other smart, it's like making it a smart device.
Essentially, yes. It allows Itron the ability to call events through the Wi-Fi thermostat.
And participants in that program receive, is it $25 for each air conditioner? Is that a flat payment of $25, or is it $25 per month?
So participants receive a flat payment of $25. If they participate in all events for the season, they receive an additional $25 at the end of the season, but it's flat. It is not a monthly payment.
But if they stay in the program and don't opt out, their inducement for not opting out is $25 at the end of the, what, 4 months?
At the end of the season, and the season is June through September. Yes, sir.
You're familiar with the M&V reports since 2018 for these programs, correct?
Correct.
What is, you recall I asked Mr. Phillips, what's Itron's contractual commitment for delivering the surrogate for capacity, if you will? First off, do you agree with that term, surrogate for capacity? I sometimes get hung up on these concepts, and I don't know that it's that helpful.
Surrogate for capacity. Help me understand what you're asking there.
Well, the amount of capacity deliverable for a curtailment event, for curtailment events by the contractor, in this case, Itron for Power Saver. What's the deliverable amount of capacity?
I believe currently it's 38 megawatt for the Itron Power Saver program.
And how much has Itron delivered since 2018?
So Itron has met their contractual capacity numbers per the contract. However, M&V looks at that and values that differently. So Itron essentially, is paid contractually is based on a 15-minute maximum reduction. But the evaluator looks at it over an hourly basis. So it's kind of two different perspectives on how capacity is being measured. But ultimately, M&V has said that the DR programs have met the needs that they were designed for.
But if the contract says Itron shall deliver 38 megawatts, Itron has delivered 38 megawatts. Is that your testimony?
Based on the mythology included in their contract, yes.
They've never fallen below that amount?
They have not fallen below that contractual amount, is my understanding, yes.
So that contract is then structured somewhat differently than this one?
Yes.
How?
I would need to go through and compare the two, but they're really different programs for a lot of reasons, mainly the voluntary nature, the constraints around the programs and the seasonal conditions, June through September, the hours that are available to be called, the days of the week that they can be called, and some of the other things.
But they don't have a baseline, like say 90% of 38 megawatts that they would have to fulfill.
I would need to follow up, Mr. Hearing Examiner, to go through the contract language and see what that baseline is.
Okay. That's fine for purposes of this discussion. Let's leave it there. Except one thing about the independent evaluator and how it evaluates performance under the M&B studies. What are its findings with regard to Itron's performance?
Their findings with Itron's performance with respect to what?
With respect to, well, that's a good question, because now we're talking about the cost effectiveness in terms of the UCT and the amount of savings, right? It's a sort of a different analysis than the cost effectiveness that we're addressing in the PNM testimony.
Sir.
Right?
Yes, sir.
So we wouldn't be able to do a direct comparison.
It would be difficult, yes.
But your position is that, well, the company's position is that this program that's proposed should not be subject to an M&B evaluation. And that, for the record, that's capital M ampersand V, M and V. Your position is that the company's position is that the M&B evaluation should not be performed with regard to the proposed program.
I don't know that that's necessarily the company's position. I think the company would be open to M&V, the proposed program, so long as that we could recover those costs associated with that.
Fair enough. Good point. Thank you. The EUA criteria, if you were applying that criteria to this program, what would we be looking at?
We would be applying the utility cost test to this program and taking into account the avoided cost and essentially comparing the net present value to the net present cost.
And when a program is first proposed in an energy efficiency docket, do you come up with an initial figure for the UCT of 1 at or 1? Or do you, in terms of an initial evaluation of cost effectiveness before the program is even implemented, is that feasible or possible?
So the way the EUA views that is individual programs within our portfolio don't necessarily have to have a UCT greater than 1, so long as our portfolio of programs maintains a UCT greater than 1. So,
Right.
So we do have programs that have UCTs below 1, but our portfolio still remains above 1.
Well, I may have led you astray by bringing up the number 1.0, because that's conceded that it's the overall total number that matters. And hopefully keeping that above 1, correct?
Correct.
But you could conceivably have, and I think I've seen it in another utilities case, where a UCT for a particular program or measure could be a negative number. Is that right?
A negative, you mean as far as being below 1?
Yes.
Yes.
Like there's I think it's a school kit program that SPS has that had a negative number. And the question is, well, how can you approve that program? And the answer is, well, the overall, for reasons that are found, that program should be maintained because it hopefully will perform better, like Peak Saver and Power Saver are essentially estimated or forecasted to do going forward. But nevertheless, the UCT stays well above 1, the total UCT. Does that make sense?
It does. And again, we have programs in our portfolio that have a UCT below 1, but there's other reasons that we continue to champion those programs. One is they support low income members of our customer demographic. And there's other reasons that we continue to keep those in.
Sounds like you knew where I was going next. In the proposed program, there would not be, that's another actually criterion under the EUEA, is allowing for a certain amount of low income program participation. Is that right?
That's right. The EUEA calls for 5% dedicated towards low income, but that's only for EE programs and doesn't apply to DR programs.
Okay, good clarification. So the customer classes, I asked Mr. Phillips about the customer classes that would be eligible for the program proposed in this case. Do you have a list of those customer classes?
I do not have a list of all the classes in front of me to list out, but in my mind, the way that I keep it simple is classes rates 2 and below are eligible to apply for Power Saver, and any rate classes 3 or greater roll into Peak.
Just so the record's clear, could you provide, pursuant to a bench request, a list of the customer classes eligible to participate in this proposed program?
Yes, sir, we can.
Okay, thank you. That's bench request number 2. The list of customer classes eligible to participate in the proposed DR program. Go ahead.
We will confirm that, but my understanding is in the new proposed DR program, all classes are eligible to participate.
Except for residential and small business. Is that right?
I would need to confirm that, and Mr. Phillips may be able to answer that, but I would need to verify what classes are eligible.
I think Mr. Brandt, at least his analysis for CCAE indicates that suggests that the residential and small business classes would not be eligible to participate in this program. But your response to the bench request will answer who is eligible and who is not.
Yes,
Correct?
sir, it will. Yes, sir.
Okay, we'll leave it there, and I'll take it up if necessary with Mr. Brandt. See if I have anything else. Okay, I forgot if I asked you, and forgive me if I did, but I see the note here. When do these programs expire, and they were granted an extension to 2023? Is that right?
Yes. Yes, sir.
Both programs.
Yes, sir.
In your experience and knowledge of commission cases, has a DR program been approved outside the context of an EUEA plan docket?
I don't know. I have no knowledge.
The PNM's existing programs are 2 DR programs, right?
Right. My understanding is they've always been included in the EE portfolio.
Therefore approved in an EUEA plan case.
Yes, sir, that is correct.
Okay. I think that's, well, if the UCT were applied to this program based on the assumptions that Mr. Reynolds has provided, do you think this program would be cost effective under the UCT test? Or is that impossible to say without doing an avoided cost analysis and net present value analysis?
I would need to look at those analysis before I was able to say hypothetically what the cost effectiveness would be.
And in that case, we're looking for energy savings, right?
Yes, sir.
Projected energy savings, not necessarily reliability criterion.
Exactly.
And also cost effectiveness in terms of spending, cost, price.
Correct.
Right? Okay. Mr. Johnson, that's all I have. Mr. German, do you have any redirect?
I do not. No.
Okay. Ms. Johnson, thank you very much. I appreciate your testimony, and it's good to finally see you in a case. I appreciate your testimony. Thank you.
Likewise, sir. Thank you, sir, for your time today.
I appreciate it. Thank you. You're excused.
Thank you.
Thank you. Would PNM please call its last witness?
Yes, our last witness is Michael Setledge.
Mr. Setledge, would you raise your right hand, sir? Do you solemnly swear or affirm the testimony you're about to give should be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Mr. Setledge, can you state your name for the record and tell us your position at PNM?
My name is Michael J. Setledge, and I'm a pricing principal at PNM.
Great. And can you identify PNM Exhibit 5, which is titled Direct Testimony of Michael J. Setledge?
Yes, I can. That's in my direct testimony exhibits.
And was that exhibit prepared by you or at your direction?
Yes.
Is it true and correct to the best of your knowledge?
Yes.
Do you have any corrections that you need to make to PNM Exhibit 5?
No, I don't.
If the same questions that were asked of you in the exhibit were asked of you here today, would your answers be the same?
Yes, they would.
So, Mr. Hearing Examiner, I will move the admission of PNM Exhibit 5.
Any objection? PNM Exhibit 5 is admitted.
And I will pass the witness.
And I forgot, I was reading here. The witness was sworn, correct?
Yes.
Okay, thank you. Forgive me for that lapse. Anybody would like to question Mr. Setledge? Okay, well, I have obviously asked you to testify live, and Mr. Setledge, it's nice to see you again.
Nice to see you, sir.
Thank you. In Mr. Phillips' rebuttal testimony at the end, he indicates that PNM believes recovery through a regulatory asset and ultimately base rates as recommended in staff's testimony, Mr. Reynolds' testimony, and also Mr. Brandt's testimony would be acceptable. The alternative of a rider proposed as the first option for PNM seems to have now been moved away from. And frankly, if I recommend approval of the program, I would recommend recovery through a regulatory asset and ultimately base rates and not the rider. So is that consistent with your understanding of where we are?
Yes, it is.
And given that preface, that it would be recovery in a regulatory asset and ultimately in base rates, and perhaps PNM's next base rate case, did PNM perform or conduct a customer bill impact analysis with respect to recovering the costs of this program, this DR program?
We have not done that analysis.
Could you perform that?
We would
Could
have
you-
to,
Go
it's
ahead.
part of the, it would be one of the many things that could be in this rate case at some point in the future. So to isolate just this, we would have to take a previous case and try to modify that with just these costs. But there were, in a rate case that we filed, there will be many other changes besides just this one thing.
That's fair, but if to the extent you could isolate the costs, I think the commission would like to know what the impact on ratepayers would be with regard to this program.
We could do that analysis.
Okay, thank you. So bench request number 3 would be for PNM to please provide a customer bill impact analysis showing the impact on base rates of all the customer classes at typical consumption. And is it fair to say, Mr. Settlage, demand levels for those that have a demand component in their rates?
Yes, that would impact their overall bills. That would impact the bill impacts. So yes.
Yes, sir. Okay, thank you. So that's bench request number 3. And that's really all I have, Mr. Settlage. Would the company have any redirect with regard to this? Mr. Settlage, is my questioning Ms. Settlage?
No, Mr. Medeiros, I do not have any redirect. Just to clarify on the bench request, though, so you want us to do a bill impact analysis for all rate classes just at standard consumption levels? And what I'm asking to clarify is, for notice purposes, in some cases, we do analysis for many different levels of consumption for residential and I believe small power classes as well. But you're not asking us to do that for this bench request. Is that correct?
I am for typical consumption levels is the term I used, and I have used in past cases. And what I've received is that that latter analysis for at various levels of kilowatt hour consumption, and I guess kilowatt demand to the extent that it's applicable.
Okay, thank you for clarifying.
Thank you for asking. All right, if there's nothing else, Ms. Settlage, thank you very much. I appreciate your testimony. It's good to see you again.
Thank you, sir.
Thank you. Okay, before we break for lunch, which I think we're going to do now for an hour, with those of you on the council on the line, I have a concern around that issue of obviously the default provisions and performance provisions. And I'm thinking that the best way to approach that right now, rather than go through another bench request, is to have that issue briefed, interpret is it section 7.1, interpretation based on Mr. Reynolds and Mr. Phillips' assessment of the 90% versus perhaps even lower than that, 80%, is for an analysis to be conducted of what actually is the baseline deliverable performance level that Itron has to meet to achieve full payment per year. And I'm thinking that issue may be one that would be fruitful for briefing. Any thoughts on that, PNM? I want to get an accurate assessment of that, and without some further analysis beyond what I've done with Mr. Phillips, I'm not sure I'm there yet to fully understand it.
Okay, and it would be analysis from a contractual legal perspective in terms of what's the base load
Yes.
under the contract.
Yes.
Okay.
I think that might be the best way to go. I don't know, but I'm throwing that out there. Anybody else have any thoughts on that?
We could certainly provide a brief, or that, we could brief that issue.
I would ask, since it's an issue raised by staff and addressed well by staff, I'd ask that PNM and staff provide briefs on this issue, and then other parties may as well. But it will be, basically briefs in chief shall be filed by PNM and staff on whatever issues we decide on at the end of the day. And then other parties may also provide briefs in chief and response briefs. In other words, they're not necessarily obliged or required to file briefs, because even if I made that requirement, not all the interveners are going to comply anyway. Mr. Gould, any thoughts on that? Ms. Zur? First, Mr. Gould.
Yes, sir. I wondered if that briefing that you were asking for was also related to the price comparisons in the testimony. I recall Mr. Phillips as saying that, say, for instance, the contracts for battery storage have minimum deliverables that are not necessarily the nameplate rating. I just wondered are we getting down to comparing resources with this briefing, or are we just trying to isolate this contract? Either way, I just want some clarity.
No, that's a very good point. I think what I will say, and what I have set up prepared to say, is that the briefing will address analysis of any other contested or disputed issues or positions. In other words, it's holistic briefing of all issues in the case. That make sense?
Yes, it does. Thank you. Thanks for that clarification.
Ms. Gould? Can you unmute yourself, please? There you go. Thank you.
Takes me a minute. Perhaps you'll get to this at the end, and so if you are going to, then just let me know. But I wanted to request that the briefing, the comments on the proposed recommended decision that are due tomorrow, perhaps be delayed and perhaps be concurrent with the briefing schedule, and perhaps be after we receive the answers to the bench requests that you're going to issue?
Absolutely. I will modify and amend that requirement. That's no longer required. You can take that to the bank. We're going to modify that requirement based on our discussion of what would be feasible for briefing, further briefing. That's a good point. Thank you. Anything else, Ms. Zur? Any comments? No?
Kelly,
let's
asked my question. Sorry.
Oh, I'm sorry. Go ahead. I'm sorry.
Kelly asked the question I had. I'm good. Thank you.
Okay. Well, if there's nothing else, let's take an hour break for lunch and come back at 2 p.m. We are in recess now until 2 p.m. Thank you all.
Thank you.
Thank you.
Oh, thank you very much.
Okay, good afternoon. It's 2 p.m. and I'd like to resume the hearing after our lunch break if everybody is ready to go. I have a few nodding yes, so let's continue with the hearing. Before I move to CCA's witness, Ms. Zur, looking at my notes, I had another issue that I was remiss in not addressing with Mr. Phillips. I was wondering if he might be available, Mr. Gifford.
If Mr. Phillips is agreeable, which I'm sure he will be, we stand by, Your Honor.
Yes, sir.
All right, thank you. Mr. Phillips, it's not in any way a contentious issue, but it's hopefully helping me understand the mechanics of the program.
Yes, sir.
And it's your direct testimony. If you look at some point here, you address the mechanics of the program on the particular hours involved. Right. And I guess what I'd like to do is turn your attention to the, I think it's in the statement of work. First off, though, there's the Appendix B, which I think is from the, not sure what it's from, but Appendix B, performance needs. It's PNM Exhibit NLP-2, page 35 to 35, the last page before the
Yes, sir. That's the heat map that was attached to the RFP.
and that's the same heat map that is included in the agreement, isn't it?
Yes, sir, it is.
Okay. So I'm going to cross-reference that. So just to refresh my recollection, using the example of risk, I guess, the degree of risk, is that what that is showing for those summer months?
Yes, sir. So what that table is showing is the relative risk of loss of load for typical days in each month.
Right. And so the most risky hour during the riskiest month is the 20th hour of July, right?
Yes, sir, that's correct.
That 29.45% figure there, which shows what is the 29.45, just focusing on that riskiest hour. Is that a silly way of putting it, the riskiest hour?
It's not a silly way of putting it, no. What that is saying is that if you total up all of the percentages there, it totals up to 100%. And so roughly, just shy of 30% of our total loss of load expectation risk is in that 20th hour of July.
And for 2023, right?
Yes, this was for it. So this table was taking the assumptions that we had the DR program in, we had the replacement resources from San Juan in, using our 2023 load forecast, all of that, and assessing what the risk profile of the 2023 expected system would be.
And a loss of load event, again, refreshing my recollection without looking back at the record in 1995, I can't recall. What does a typical loss of load event entail?
A loss of load event is any point in time during our simulations where we weren't able to serve all of the load in a given interval, in a given hour. So it could
How
be
much of the,
I'm sorry, go ahead.
no, you go ahead.
It's by events though, so it's counting the number of events. It's not referring to the magnitude of the loss of load.
Oh, the number of events.
Yes, sir.
And it might be, how sensitive is it to what part of the system it might be on? Or is there that sensitivity?
Well, all of our load, I mean, we don't have the load broken out all the way down to the distribution level. The load is really categorized in PNM North and PNM South. So it's not all the way down to the nodal level.
Okay. And typically, what would an event entail? Would it be for an hour's loss, or?
It could be as short. It could be as short as 5 minutes. It could be longer than that. The number of events is what's being counted, and the model itself gets down to a 5-minute frequency.
And so the the far right column, 43%, those numbers that add up to 100%. That 43% represents what?
That's the total risk across the 20th hour for all months.
Okay. And so when Itron uses this appendix B, what is the significance to the contractor?
That helped them inform their bid. If we were to go to the statement of work at page 9 of the statement of work, or it's page 22 of PNM Exhibit NLP3. I guess I should have said starting on the previous page. There's three tables there that then show what the breakdown of the capacity reductions covered by the contract are, by the typical day and typical month, and then there's 3 matrices: one that's for Monday through Friday, one that's for Saturdays, and one that's for Sundays through and holidays.
Okay. And so I guess, help me out with, guide me through how the contractor would use this data.
So when we're looking at how the performance standards and default conditions in the contract work, we would be going to those tables in the statement of work on pages 8 and 9 of the statement of work. And so if we're measuring performance, it would be, and the event was called on a Saturday, it would reference the matrix of capacity reductions for a Saturday. If it was called on a Monday through Friday, it would reference the Monday through Friday matrix. And same thing for Sundays or holidays. So there's different levels of commitments for the contract based on whether it's a weekday, a Saturday, or a Sunday or holiday. Mainly because if they're going to be targeting commercial and industrial customers, there might be less commercial and industrial load available to interrupt on a Saturday or a Sunday as opposed to a weekday.
So how would an event transpire between, they communicate with the designated dispatch operators, designated system dispatch operators?
Right. Our system operators would notify Itron that we're calling an event, and the contract requires a 10-minute response time. So Itron then it uses their communication protocols to remotely interrupt the devices on their commercial and industrial customers to reduce load within 10 minutes.
The customers have 10 minutes notice.
Right.
And how much lead time does the dispatch operator give Itron? of a planned event?
It's set up so that they could call them, like if I was the dispatcher right now and I needed to reduce load, I could call Itron right now, and within 10 minutes they would need to deliver the capacities stated in the capacity matrix.
Okay, so if, let's say we're right now. What hour are we in? We're on a weekday. And let's just say it would be 7 hours. I mean, excuse me, 7 megawatts.
Yes, right now we're on a weekday in January, 2 o'clock, so we're hour 14. So that Itron right now would be obligated to provide 7 megawatts of demand reductions within 10 minutes.
But typically, you're anticipating that the total, focusing on the 100 hours for those 4 summer months, that's where the events are more likely to occur, are in the summer months?
Yes, sir. So when we looked at it, there was as expected, based on how much risk on the system there is, and that would be going back to the heat map. That's when we would expect to call the events the most, because we would be concentrating the use of the limited program, right? Because we only have 100 hours to use in the 4 summer months. And so we would be, holding that as long as we could until we needed to call it. One of the other good things about the 10-minute response time is it allows us to hold it as contingency reserves. So, we can hold it back until we absolutely need it.
And you could call the event for up to 4 hours under the agreement, right? So it could be.
I'm sorry.
Go ahead.
That's right.
It could be 15. I'm sorry. Go ahead. But now let me finish. I'm sorry. Yeah. It could be 15 megawatts for hours 13 through, conceivably, just hypothetically, hours 13 through 16 in July, 15 megawatts for each hour. Am I reading that correctly?
That's exactly right. We could call it for 15 megawatts for up to 4 hours in July, or we could call it for a single hour, so long as we don't go for more than 100 hours total across the summer.
And typically, what kind of devices are they attaching to? What kind of equipment,
I don't know all of it. A lot of it is going to be focused on air conditioners and cooling equipment, things that are weather sensitive. That's why we see more higher capacity reductions in the summer months, because there's more to interrupt.
And Itron would need the confidential customer data in order to identify potential customers and communicate with those customers to see whether to gauge interest.
That's right. In order to go and market to those customers and try to enroll them in the program, they would need to know which customers they could target. And that, if you don't mind me going back in terms of the customers that are eligible, there's no restrictions on any particular customer class to participating in this program, but Itron is going to target customers 100 kilowatts or larger in size. But in order to go and find those customers, Itron will need to know who they are, as well as there's a provision in the statement of work. If we go back a couple of pages, bear with me, please. Look, I will find it for you. There's a provision within the statement of work that essentially says Itron cannot go and target customers enrolled in the current program.
Okay.
And so part of what Itron would make sure is that they're not going to be marketing to customers that are already enrolled in Peak Saver, because we don't want to rob Peter to pay Paul, essentially.
And they'd be poaching from another contractor's program in that. sense.
Right, right. So we need to make sure that they're not actively going out and doing that. There's no prohibition, for a customer to say, I'd rather participate in the current program or the new program, but Itron would not be allowed to go out and specifically try to poach.
And what's the benefit to the typical customer participation in the program?
Are you asking what is the difference in the incentive payments?
Right.
I think that would be confidential to the contracts. I guess if I'm happy to share it with you, but I think we should go into a confidential session.
How about are the incentive payments under this program known, published?
Published, not that I'm aware of. I don't believe the incentive payments for any program are published. I believe they're or at least for the peak saver, I don't think it's published either. It's done through negotiations between that program's administrator and the customers in the program.
Okay, I just for the sake of it, for the sake of inclusiveness of the record, I would like to understand the difference in incentive payments. That I first off, before I go, that I'm not going to do that here because that would require me to suspend the YouTube stream, and I don't want to lose that since we had trouble setting it up this morning. So I'm going to pass on that right now and consider how I should approach that, if at all, with regard to incentive payments, except to say that I'm not sure I understand why Itron's incentive payments to customers to attempt to induce customer participation would not be known. Can you address that?
I mean, they're known to us and from the bidding information in Itron's response to the RFP. I don't believe, and I can double check on this, but I don't believe we've ever published, for example, the peak savers incentive payments. Those are done on a contractual basis between the customers in the program and that administrator. And so if their or Itron's were to become public, it would create obviously that more competition between the two programs.
So you've not disclosed that with regard to peak saver in the energy efficiency dockets?
Not that I'm aware of. I talked to Zach and his team about that previously, and that's what they had also made me aware, is that while the Power Saver residential program is more public information, the Peak Saver has been, maintained as confidential.
Okay, that makes sense. At least factually, it makes sense. So, and then to take it to the next step to make even more sense, it's potentially possible that customers, potential C&I customers, you said 100 kilowatts and above?
That's the target demographic that Itron will be going after, yes.
They could negotiate with Itron an incentive?
That's the same way also that the Peak Saver program works, but Itron would be able to negotiate with them what the incentive payment structure to them would be.
And that might actually, that flexibility and confidentiality in the business community might actually help induce participation that might not actually otherwise be cultivated or induced if the incentives were not negotiable. Does that make sense?
I think that's right. And it makes sense to me if you have a customer that's able to interrupt more frequently or more times, Itron or the other, in Peak Saver, they're going to want to have a portfolio that totals more than what they're contracted for, try to make sure if certain customers didn't perform as expected, or if they don't want to have as much fatigue in the program, they could rotate their called interruptions so that they are maximizing the contract performance across events.
And it occurs to me, and this may be getting far afield, but a particular commercial customer, the fact that it's interrupting may actually be proprietary or confidential business information, because there could be some sort of a competitive advantage, say, to a big box chain to interrupt its demand or load at certain times of the day in relation to competition with other big box, as an example, big box chains.
There certainly could be. I'm trying to think. There certainly would not be an easy way for customers to know whether or not other customers are undergoing a demand response event. Though I do know that you can, if you're enrolled in the programs, you'll get notifications. So if you know your competitor is also enrolled, you could hypothesize that both of you are being interrupted or neither of you are being interrupted.
How would you know your competitor's enrolled though?
Yeah, that is, I don't know. Only if you did know that would you know that they were probably also interrupted. But
the customers in the program, their identities might be confidential as well.
Their identities would be confidential. We would not be releasing that information other than to Itron in terms of who they could market to, and Itron would not be releasing that information to other customers.
Okay. Anybody have any questions around this line of questioning with Mr. Phillips, or any redirect?
Nothing from me, Your Honor.
Mr. Phillips, thank you very much. That was very informative, at least from my perspective. I appreciate your guidance and testimony on this issue. Thank you. All right, CCAE, would you please call your witness?
CCAE calls Justin Brandt.
Mr. Brandt, would you raise your right hand for me, sir? Do you solemnly swear or affirm the testimony you're about to give should be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you.
Good morning, Mr. Brandt. Would you state your full name and employment for the record, please?
Justin Brandt, I'm a co-director of the utility program at SWEEP, the Southwest Energy Efficiency Project.
Do you have what's been previously marked CCAE Exhibit 1 before you?
Yes, I do.
And what is that?
It's my direct testimony in this proceeding.
Was that prepared by you or under your direction?
Yes, it was.
Do you have any corrections to make?
Not at this time.
If I were to ask you the same questions today, would your answers be the same?
Yes.
Is it true and correct to the best of your knowledge and belief?
Yes, it is.
I asked to move CCAE Exhibit 1 into evidence.
Any objection? CCAE Exhibit 1 is admitted.
Pass the witness, Your Honor.
Thank you. Would anybody like to cross-examine Mr. Brandt? Good afternoon, Mr. Brandt.
Good
Unless
afternoon.
you're in Hawaii.
No, Colorado, sir.
No. Nice to see you again.
Nice to see you.
Thank you. I guess I'd like to start, before I forget, with something that Mr. Phillips mentioned in his testimony. Were you present when I was asking him questions about the ability to opt out of the customer's ability to opt out of programs, and how rare or common that might be to have that provision in a program?
Yes, sir, I was here.
He mentioned the MISO program in particular, that if I'm not mistaken, if opt-outs are not allowed for customers in that program or that whatever DR program or type of DR program, or they would not be allowed to participate any longer if they attempted to opt out?
Yes, sir. I
Could you
remember
elaborate?
that question.
Are you familiar with that program?
I'm not familiar specifically with the MISO program, though I am familiar with programs in other organized markets, such as the ISO New England demand response programs. So I feel like I could talk generally about those types of programs, but I'm not, I don't know the specifics of the MISO program in particular.
But are they independent system operator specific types of programs that do not allow for opt-outs?
I mean, my understanding of those programs is it depends what the entity is that has the obligation. So, for example, an aggregator, a company such as Itron, could bid in resources that would be called upon, and it would have to deliver those resources. But there's nothing inherent in those contracts that would say that no individual customer could opt out at any one time. The aggregator, the company that has the obligation, is obligated to deliver when called upon. But I guess it's a little different than the opt-out. Well, that's not my understanding. In the opt-out provision in this contract says that no individual customer can opt out at any time, which is, I guess I see different as rather than an obligation on the sort of aggregator, if that is the entity that has bid in that resource.
Well, the aggregator here, Itron, can't opt out. It has to meet the, whatever it is, 13.5 megawatts, right?
Correct, but I believe there's also a provision in the contract that says no individual customer that Itron would contract with could opt out of an event. So as I said in my testimony, I feel like a provision like that really, it makes it so, while not explicitly disqualified, that Itron could not target residential or small commercial or any mass market customers in the program because it would violate that provision.
I understand that. But my understanding of Mr. Phillips' testimony is that individual customers of the aggregator could not opt out.
In the contract with Itron, yes. But I'm saying
I'm talking
sorry,
about
go ahead.
in the MISO example.
Oh, again, I'm not familiar with MISO, but in ISO New England, where I do have experience, that my understanding is that's not the case. The individual customers, the aggregator has the obligation, and if they choose to aggregate mass market customers, there's not the same requirement on the individual customers.
So even large commercial customers of the aggregator in New England.
Well, it would depend on the contract between the aggregator and the customers, which would not be public. But I guess I'm not to the best of my knowledge. So yeah, I don't know what contractors an aggregator like Itron would have with their customers. But if there are mass market programs operating in some of the organized markets in our country.
Outside of those, and in your experience and to your knowledge, how common are these particular restrictions? Let's go over them. First, we're talking about the no opt-out provision. How common is that in the industry, in your experience?
I guess I'm not familiar. I haven't looked through a lot of, these contracts are often proprietary, and I don't know specifically related to an opt-out provision, how common it is. I guess I can say in a lot of having this kind of provision that each individual customer can opt out, I think is unusual in my experience, though it's not unusual to structure payment based on actual load delivered, or have a requirement on the aggregator, if there is one, that they must deliver the load.
Go ahead.
And I was going to say, as I said in my direct testimony, I wasn't arguing with PNM that they need load that will be delivered when called upon in a program like this. But I think there are other ways to structure a contract to ensure that that load is there, rather than having a provision that sort of individual customers cannot opt out of any events.
and we can't see as I'm learning, we can't see the contracts publicly between the contractor and the participants in the program.
Yeah, in a program that targets large energy users, I wouldn't expect, that's the obligation is between, PNM and Itron, and how Itron goes and recruits customers and delivers that program. I wouldn't expect the PUC to have oversight or that to be publicly available.
But that's what I want to focus on, is the contract that's before the commission. And so with contracts like this, in your experience, how common is it to require a no opt-out provision at this level before
I'm not familiar.
Regulatory commission?
I'm not familiar with any other examples that include a no opt-out provision.
Excel in Colorado?
As far as I know, there is no such provision, but as I said, I haven't reviewed that contract recently, so I can't say for sure.
And okay, the other one of the other restrictive provisions is the 10-minute interruption notice. That's uncommon in your experience or in your testimony?
Yes, sir.
How frequently have you seen such a short interval for notice?
There are programs that run 10-minute or less, and it's a very valuable resource if it can be available in such short notice. But as I said in my testimony, as a minimum requirement for a capacity-focused demand response resource that's not trying to provide, contingency reserves or other services as its primary objective, it's unusual in my experience to have a 10-minute minimum notice, and often would be a longer, minimum requirement. And if a contractor could deliver a faster resource, then there's obviously more value in that, and that should be taken into account.
What other restrictive provisions remain after the contract was negotiated and presented to the commission? Do you recall?
I think PNM in its negotiation relaxed a lot of the other provisions that I'd identified as restrictive. I guess the point I was making is that the RFP sought a very different resource than CCAE modeled in the previous 00195 proceeding, and PNM ended up contracting with a much different resource than it had originally solicited. So it's hard, for me, it means that there may be, if PNM were to go out to bid for a resource that would meet the criteria of the contract that they ended up entering into, they may get more bids at a lower cost. It's really hard for us to know, what resources available and at what cost, given the nature of the way that they went through the contracting process.
Were you concerned at all that the restrictiveness of the bid, of the RFP, limited the number of bidders?
Yes. As I said that in my direct testimony.
And taking it to the next level, do you think that might not have been an accident? That it may have it helped select the bidders who might provide a suitable response?
I can't speak to
too far.
I guess I can't speak to what PNM's motivation was, other than what they've stated in this proceeding, that about the need of the resource. But I do think the provisions, this was a very tight timeline in a solicitation, given just the nature of the requirements the commission put on PNM and the need to have this resource in place by 2022. And that coupled with the fact that there were a number of restrictive provisions for the minimum requirement in the original RFP, I think that potentially drove down participation, or likely drove down participation, and may have been one of the reasons that only 2 bidders responded to the primary objective. I think it's a little telling that one of the bidder they ended up contracting with is a bidder that is familiar with their system, they have an existing relationship with. I think Itron they have more information just given their existing relationship with PNM than other bidders may have, who, given the tight timeline and the restrictive nature, decided to sit this one out.
And you were in attendance, I believe, when I discussed with PNM's witnesses the idea that this resource was added on at the end of the CCA1 portfolio. My understanding is from your testimony that it is I'm trying to find the language here, which was what I was looking for, frankly, that it was in your testimony that it's a significant part of the portfolio. And I highlighted it here and I can't find it right now. I just read it at the break. And you recall when I was talking to Mr. Phillips, I asked him to look at that table of the CCA1 portfolio.
In Mr. Reynolds'
yes.
testimony?
Yes. Yes.
Yes.
And could you characterize the significance of the demand response resource in the context of the overall portfolio?
I guess I see it as a significant piece for a couple of reasons. From a capacity standpoint, it's not, when we're talking about 900 megawatts or so of 950 megawatts of solar and storage, it's a small portion, but I think it provided in our modeling in 00195, demand response provided a lot of value as part of a broader portfolio that included solar and storage, in that it served a need to deliver capacity reductions during very specific peak times when our modeling in that proceeding identified a resource, a capacity constraint. In addition, I think there's a lot of value in diversity of resources and not putting all of your eggs in sort of one basket, and the fact that we're not putting all our sort of eggs in the storage basket or solar and storage combined basket, that there's a value in having demand response as part of this broader portfolio of resources in reducing some of the risks moving forward. And I guess I'll say, just from a broader perspective, and Mr. Phillips touched upon this during his testimony today, I think everything I've seen in the literature, and as we move forward with a electric grid that is more reliant on renewable resources, demand response and reactive load is going to be a large part of integrating those resources cost effectively. I guess we see this as a great first step. Demand response can provide a lot more benefits than just capacity, but by including this capacity-based resource as part of our portfolio, we see it as an important step in New Mexico as you move towards 100% renewable grid as required by statute.
I'd like to go back to what the commission approved in terms of the 24 megawatt demand response.
Yes, sir.
program. That was your proposal, right?
Yes, sir. Or it was the modeling that identified in 24 megawatts of available demand response resources that was then sort of considered as part of CECAE1 was my testimony, and was something I did. Yeah, was work that I conducted in the previous proceeding.
And what that was based on, was it an expansion of the Power Saver program?
That's what I based it on in that proceeding, and we looked at a number of different options about what types of demand response was available, and ended up with that one, I think, as a conservative assumption. It's really hard without, intimate knowledge of the PNM's resource to say how much demand response would be available in larger customers, just because that customer class is so heterogeneous. Whereas when we look at mass market customers, they're a lot more predictable. We know how much air conditioning exists in PNM service territory for residential and small commercial customers. And based on that and sort of best other programs around the region, we estimated the amount of resource we thought would be available by expanding the existing Power Saver program up to what regional best practices around participation in residential and small commercial air conditioning load control programs.
I'm curious, did you do a cost analysis of the CCAE DR proposal?
I didn't specifically. We ended up using we used the assumptions around the costs of the existing PNM Power Saver program, which is consistent with similar programs around the region.
So if I were to ask you if you had data, you would point me to the cost effectiveness analysis that you did in this case.
I haven't conducted a cost effectiveness analysis in this proceeding.
Okay, I am mischaracterizing then the table attached to your testimony as, what is it, JB-4?
So let me bring that up.
It's not labeled that, I don't think, but I think that's what it would entail. It's the last page before the affidavit. The tables.
In the instant proceeding?
Yes.
Okay, so that's part of JB-3. That is a interrogatory response from Mr. Phillips and Mr. Johnson. So that was an analysis we asked PNM to conduct. And it wasn't meant to assess cost effectiveness. It was really just meant to compare the cost of the contract in the instant proceeding with the sort of both contract and realized cost of the current Peak Saver and Power Saver programs.
Comparing the cost of the proposed DR program to the one that you proposed in 19-195 ET, I asked you for the numbers from the former proceeding and your proposal. What would you provide?
Subject to check, my recollection is we assumed $95 per kilowatt year, but I would need to confirm that.
Would you provide that in response to a bench request?
I can.
Please do. That's CCAE bench request 1. And I should note that pursuant to, as I indicated before and will indicate at the end of hearing, pursuant to Rule 35K of the Commission's procedural rules, those involving the rules of evidence, parties will have the opportunity to provide a reply to the CCAE response, as with PNM's bench request responses. So I'm asking you for the price or cost data regarding the DR program proposed and I guess approved by the commission in 19-195.
And that would be the assumption that, just to confirm, the assumption that CCA made in proposing that resource.
Yes.
Okay.
Yeah, just as much information you can provide that will eliminate any confusion in the replies, and my confusion would be helpful. So regarding assumptions. Because I anticipate that from some of my reading of the testimony here that your response may likely elicit a reply from one party or more.
I'm happy to provide that.
Thank you, Mr. Grant. So let's look at that. Go back to JB3.
I'm there.
And then cross-reference Mr. Reynolds' direct testimony. You were here for my discussion with Mr. Phillips, I'm assuming regarding Mr. Reynolds' analysis and conclusions.
That's correct. Just give me a second to bring it. I don't have Mr. Reynolds' testimony open on my computer right now. Okay, I have it now. Thank you.
Thank you. So let's look first at JB3, your exhibit.
Mm-hmm.
What I understand it to show is that the cost, that last column, cost reliable kilowatt per year, shows the proposed DR in the top table for 2019 at the proposed DR program at $118 versus $142 for peak saver kilowatt per year, and power savers at 212. Is that correct?
Yes, sir. And in my understanding of how PNM calculated that is they, just took the total annual cost of the program and divided it by what they would consider the reliable number of megawatts based on the Evergreen's EM&V report for 2019 and the estimates from their contractors for 2020, as the evaluation is not yet complete for 2020.
Is there a typo in that column total cost? Should it be $17,733,390?
I don't believe so. I think this is the annual cost. So the 17 million is it's a 10-year contract.
Okay, that's the annual cost then. All right. If I asked you here to plug in where the 50 megawatts is, plug in 13.5 megawatts, could you provide, if you have a calculator handy, or would it be more efficient for me to ask you to provide, pursuant to the bench request number 2, an analysis based on Mr. Reynolds' assumptions and conclusion?
I think I could do it off the top of my head, or with
that'd be
the
great.
calculator in front of me.
Let's do that then. Because I think we'll see where the briefing goes on this issue and where the conclusion is about how much the actual effective capacity commitment that Itron has under the agreement. But assuming it's 13.5 megawatts, what would the cost reliability kilowatt per year be for the proposed DR program?
I guess subject to check, I'd want to say approximately $131 per kW year.
It would be what?
$131 per kW year.
It's actually what is reflected in Mr. Reynolds' JJR4 then?
Let me bring that up.
And the answer would be yes. I believe.
Yeah, it's the same. Yeah, I agree that his calculation would be the same as this table, assuming there's only 13.5 megawatts of capacity available and not 15.
Assuming that the contractual amount required and for full payment to Itron is 13.5 megawatts. In other words, do you have Mr. Phillips' testimony?
Yes, I do.
Okay. Do you have PNM Exhibit 2, PNM Exhibit NLP3, page 26 of 36? It's the Itron statement of work, page 13 of 23. You have that?
Yeah. Yes, I have it in front of me.
Would it be more accurate to put in the column where the column for those, the 10 year or the 9 years, I guess, lines 13 through 22, you see that column quantity?
Yes.
Would it be more, could one substitute 15,000 kilowatts for 13,500 kilowatts and still end up with the same resulting figure of $1.68 million per year?
I guess assuming if you also change the unit price to the 130, sorry, what?
No, 112. Yeah, well, yeah. But irrespective of what it is, if I guess what I'm trying to point out is that on the quantity, if Itron delivers 13,500 kilowatts in on line 13 all the way down to line 22, Itron, pursuant to the contract, the way the contract is structured, Itron would still receive the full 1.68 million.
I believe that's correct based on the conversation you had with Mr. Phillips earlier. I guess I would add that I agree with him that I don't, Itron has a lot of incentive to, maybe it's not financial incentive, but they're a big player in the market. They have a relationship with PNM. I wouldn't expect them not to deliver the full amount of this contract, but I agree that based on the conversation you've had with Mr. Phillips, it appears that they could deliver an average of 13.5 megawatts and still receive full payment.
So the incentive to Itron would be reputational and for cultivating future business?
I believe so, yes. They're, the utility industry is not that big, and, that they want to maintain their reputation as a trusted demand response provider. They're one of the biggest players in this market. I don't expect that they go around signing contracts that they don't intend to fully meet.
Well, they would be fully meeting it at 13.5 megawatts.
Well, my reading of their obligation in the tables you discussed with Mr. Phillips later in the contract is they're obligated to deliver 15 megawatts during summer peak hours. And they may not be financially penalized by not meeting that, but they're still not meeting the sort of specific terms of their contract.
They're actually obligated to achieve 90% of the expected demand reduction. Correct?
I guess my reading is they would default on the contract and be subject to penalties if they don't meet it, but I'm no contract.
I'm reading the contract. Right. I want to get in an argument. I'm not arguing with you. I'm just reading from the contract. And we'll have an analysis hopefully from the parties on that. But it seems to me that if Itron achieves 90% of the expected demand reduction it is in compliance with its obligation to deliver the replacement for the capacity, the reduction of the amount. And that being the case, if Itron said, well, look, we've done our level best, and this is what we've come up with in terms of developing customers, because as you all acknowledged in the case where the agreement was approved, it's a relatively tough environment for demand response programs and energy efficiency programs and load management programs writ large. So we've done our level best and we've complied, and that means our standing in the industry remains top notch or remains good. Isn't that a possible outcome?
Sorry,
Because
can you
guys,
I guess
you all, they've said, PNM has said it's a challenging environment effectively.
Yeah, I guess I don't necessarily agree with that characterization. And that's what I try to say in my testimony. I agree with there may not be a lot of 24 megawatts of resources that meet the minimum requirements that PNM set in their original RFP available. But as I stated, I think there were a lot of the terms in that contract disqualified demand response in the market. So I guess, I don't agree with the characterization that sort of the low-hanging fruit is all gone. I think we don't know at this point because we haven't probed the market to see if the resource that CCAE modeled is available and at what cost.
So if I understand your testimony, what you just said is that we don't know whether the CCA model that the commission approved was available.
Correct.
That's your testimony then?
I mean, yes, that's what I mean. I said that in, I think the contract with Itron, it goes beyond what CCA modeled, and it's a valuable resource. And it doesn't mean the commission should reject that resource out of hand. But I guess it also, to me, doesn't mean that you can't sort of categorically say there is not 9 megawatts or any more resource available because we've sort of collected all the low-hanging fruit, because we don't know. The RFP didn't look for the resource that CCA modeled or the resource that PNM contracted for with Itron. It looked for a different resource.
I was trying to find the particular language from Mr. Phillips' testimony where he talks about the estimates from the IRP for performance being less rosy than those presented in, I believe, in the last energy efficiency case. Are you familiar with that testimony?
I am generally, and I've reviewed the demand response potential study that PNM has contracted for, I believe, to inform the IRP, though I am not intimately familiar with that potential study, but I have reviewed it.
Okay. I'm trying to find that. I want to try and nail that down. So I'm trying to find that testimony. And so I'm searching potential for the potential study. And there was an estimate of a certain time period, and I can't find it now. So I'm going to leave it there. But I think I've flagged the issue for a briefing if the parties want to address that in relation to our colloquy on this issue. Because there is a somewhat of a difference of opinion. I think it's fair to say. Would you agree, Mr. Brandt?
I would.
Okay, I'll leave it then for further assessment if necessary. Let me see if there's anything else I want to ask you. Just generally speaking, do you have any response to the rebuttal criticisms that Mr. Phillips made regarding your testimony? In addition to those we've already discussed?
I guess we haven't discussed the sort of PNM's, assertion that sort of their existing programs are sort of no longer delivering at the expected levels. And I guess I'll agree, I think when you look at the table in Mr. Phillips' testimony, that and figure NLP1, that for the Peak Saver program, there was not good. In 2021, in a few events, sort of later in the year, they did not get the full resource that they'd contracted for. But that was the first time something like that had happened. So I guess I'm still, if I were in PNM's shoes, I would be going to my implementer and trying to figure out, how we can improve the program or do something different moving forward, rather than just saying, oh, we can't count on this resource anymore. This was a phenomenon that we saw one time for 2 or 3, maybe 4 events in August of last year. Only on the Peak Saver side, I think the Power Saver continues to deliver a pretty stable resource, as shown in this graph. There might have been some slight decline, but I guess PNM has been indicated that they've, gone to their contractors and tried to figure out, what's the problem. They're just saying, well, we can't trust this resource.
Mm-hmm. Yeah, I remember what I said, where's the effect of far less rosy projections or forecasts. And you're referring me back to the rebuttal testimony. I found that statement from Mr. Phillips where he says, and it's on page 11, starts on line 14, that last sentence, and I'll read it into the record. PNM's more recent energy efficiency potential assumptions developed by Applied Energy Group for use in PNM's upcoming Integrated Resource Plan, IRP, show that the ultimate result is that the potential efficiency gains for reasonably priced energy efficiency measures, in fact, are less over the 2021 to 2040 planning horizon compared to what was assumed in the 19-00195-UT case. You care to respond to that assertion?
Sure. So I guess first I want to say I think this is talking about energy efficiency more broadly and not demand response. So this is specific to the what PNM characterized, I think, as the secondary resource in objective, the 16 megawatts. And I guess as I said, I'm not familiar with the details of the potential study beyond having reviewed it briefly. But I guess I can say my understanding is, so as you discussed with Mr. Phillips, in 19-00195, PNM assumed a demand reduction from energy efficiency programs of 10.6 megawatts per year. And that number was irrespective of the amount of energy savings they got, which was an error we felt in their modeling, which in 00195, I corrected that error. You know, you'd expect the more energy savings achieved by a utility, the higher the demand savings would be. That's, you know, what we expect as you increase savings, you increase demand savings, even if that's not your primary goal from an energy efficiency program. And again, what we assumed for these early years in the program, I think was approximately 14 megawatts per year. So I think that incremental 16 megawatts is 4 years, you know, 4 megawatts incremental per 4 years. And as Mr. Phillips stated in his testimony earlier, they're expecting to achieve over at least the next 3 years, 20 megawatts of reductions per year. So higher than CCAE assumed in its modeling. So I guess I have trouble reconciling that fact with this statement, you know, and maybe saying in the out years of a potential study. So when we're thinking of 2030, 2040, that their analysis is showing there's less available than their original modeling. But I think potential studies are notoriously hard at predicting that far out, like any modeling. You know, you're trying to predict technologies. Most potential studies don't assume technology gets better, which, as we all know, or more efficient, that's not a reasonable assumption. You can't assume that the best air conditioner in the market today, or, you know, something that's an R&D today is going to be, that's probably going to be market average in 10 years. So I think potential studies can be good tools to help planning in thinking about what's available, especially in the near term. But that it's unreasonable to say that a potential study, you know, we're seeing higher achievement in the near term in reality, not in a potential study in the plan that PNM has had approved by the commission and is currently implementing. And I guess if PNM here, my reading of this is they're saying, well, in the out years, 20, 30 years from now, you know, 20 years from now, we see less potential than we assumed in 2019, 00195. I guess it's hard for me to, you know, that's a long way out to be making assumptions. I think focusing on the next 5 years or 10 years is more valuable. And I guess what we're seeing is higher energy efficiency than CCA modeled or PNM modeled.
Okay, that's all I have. Would the parties like to follow up? I'll allow any questioning. Mr. Brandt? How about redirect? Ms. Ziller?
I would like to do redirect. May I have about 5 minutes just to look over my notes?
Let's take a 5-minute bathroom break then, or a note review break.
Thank you.
Does that work? Okay, we're in recess for 5 minutes then. Thank you.
Okay, are we all back? First off, can you hear me? My AirPods decided to not work, which happens frequently with Zoom. So I had to change. Mr. Are you ready for redirect?
Yes, Your Honor. Thank
Please
you.
proceed. Thank you.
I want to clarify one thing you said, Mr. Brandt, the amount of energy. So you were correcting PNM's assumptions regarding energy efficiency, and you mentioned PNM assumed 10.6 megawatts per year, irregardless, and you said irregardless of energy savings. And I look back at that. Can you clarify, what do you mean by that?
So this is in reference to the modeling that I did in case number 19-00195. So PNM had an assumption around savings and spending for energy efficiency in each year within their modeling in the original San Juan retirement case. And generally, there's a correlation between spending and savings. You'd expect that the more money you spend on energy efficiency, the higher the savings is. So I guess both of those numbers rose in tandems, both expected energy savings and spending in PNM's modeling assumptions, but their assumption around the capacity reduction associated with those energy savings remained flat at 10.6 megawatts per year. So we corrected that assumption to sort of maintain the relationship between energy savings, spending, and capacity reductions that PNM has seen in their recent program implementation. So I believe in my modeling, I based it on spending rather than energy savings. But I sort of, those two things are correlated. All three of those variables are correlated generally.
So basically, you were saying there's a relationship between the amount of spending versus achieved capacity savings.
Yeah, you'd expect that. The more money you save, the more energy you save, and the more capacity you would reduce.
I'd like to clarify another point. When you were telling the hearing examiner that you don't know the amount of demand response available to PNM, were you referring to the potential study? What were you referring to?
No, I guess I think I was referring to the fact that PNM stated it in their testimony that sort of all the low-hanging fruit in demand response has been harvested, and there's only 15 megawatts available, and there's no more. And I guess I was merely trying to point out that given the provisions in the original RFP that I point out in my testimony that were, highly stringent and very different from the resource that CCAE modeled, that, we don't know if PNM were to go out to bid for a resource that matched the CCA modeling, or even a resource that matched their final contract. There may be, significantly more DSM available. So we don't know, based on the results of the RFP, that there's no more available, or at what cost that resource might be available.
Did CCAE model a DER resource that would be required to perform outside of the summer peak hours?
No, we assumed a resource that was available for up to 100 hours during summer months.
And you saw the heat map that was attached to Mr. Phillips' testimony. I don't know if we referred to it as a heat map. That was the chart that had the number of hours in the day and showed when demand response was most valuable. Which exhibit is that? Can you help me here so I can?
I'm trying to pull it
clarify
up.
The record.
It is PNM exhibit NLP2 on page 35.
Do you feel that chart shows a need for winter demand response resources?
No, I mean, I think it really highlights that, at least in 2023 on PNM system, they're most in need of capacity during summer peak hours. So they're the vast majority, if not all, of the hours with loss of load probability occur in the months of June, July, August, and September, between the hours of 17, so between the hours of 5 and 8 p.m.
The hearing examiner was asking you about mass market programs in MISO. Could you just explain generally, how can an aggregator, let's start with terminology. What's a mass market program? Is that the same as an aggregator?
No, and I guess when I talk about mass market, that would be a program targeted at residential or small commercial customers. These customers are often more, homogeneous. A home generally looks like a home, though they may be different. So they're marketed to the mass market. They're not really tailoring them to the specific needs of any customers. They're marketing a program broadly because the needs of each customer are similar. So, they're, again, generally looking at residential or small commercial customers.
How is an aggregator, or I don't know if I should address these separately, tell me, but how does an aggregator or someone who delivers a mass market DR program, how are they able to provide a certain minimal level of megawatts performance guarantees while allowing the electricity consumers to opt out of events?
I mean, there's a number of strategies they could take. I think, at a minimum, most would oversubscribe the program. They would get more megawatts than they're required to deliver, so that there can be a certain number of opt-outs in each individual event, and they'd still be able to deliver the load that they've committed to. There are other strategies that an aggregator could take in terms of how they're incenting customers. Rather than just giving everyone a flat fee, you can base it on actual performance in each individual event. That's what a lot of aggregators in California, I believe, are starting to do. And with technology, there's a lot of opportunities here where, with smart thermostats and pre-cooling, there are ways to get around some of these issues we're seeing, or PNM may be seeing, around customers opting out and reduced performance, because the program they're currently running is not particularly sophisticated. They're primarily using switches as well as a small amount of thermostats, but these aren't, the Nest thermostat or Ecobee you could buy at a store. It's a thermostat provided by their implementer. So I think, with technology and a lot of the new smart thermostats you're seeing, the program performance is improving in mass market programs. And there's a lot of utilities around our region that are installing and relying on significant amount of capacity from residential and small commercial thermostat programs. I think, for example, APS, Arizona Public Service Company, a utility in Colorado, is expecting over 50 megawatts from their smart thermostat program in the next year, which they started 2 years ago, and they're ramping it up at a similar rate each year, so 20 to 25 megawatts per year. And they're counting on that capacity in their IRP and as a resource within their system.
Okay, thank you, Mr. Brandt.
Thank you, Ms. Sir. Just to follow up with another question, Mr. Brandt. In your opinion, do you think this DR program should be evaluated against the EUEA criteria?
No, I don't. I think it could be helpful to evaluate it against it as a comparison, but this is really a resource that is part of a portfolio replacing generation, and the traditional cost effectiveness analysis required in the EUEA doesn't necessarily apply here. We're looking at the comparison of this resource against other generation capacity resources that can help meet the environmental goals of the state of New Mexico. But as I said in my original testimony, I think, having an independent evaluation would still be helpful, including it within the evaluation process. We're not opposed to that. A contract like this, because it always helps to have another set of eyes on any program.
And my understanding from Mr. Johnson's testimony is that PNM is not now opposed to the DR program being subject to an M&B evaluation.
Yeah, I believe I heard him say that earlier today.
Is there anything else?
No, thank you.
Thank you, Mr. Grant. I appreciate your testimony. Good to see you again, even though it's through Zoom.
Yeah, thank you, sir.
You're excused. But if you'd like to hang around, please do.
I appreciate it. I probably will. But thank you. Have a great
Thank
afternoon.
you. Thank you. You too. All right. Staff, would you please call your witness?
Thank you, Mr. Hearing Examiner. Staff calls John Reynolds. John, you'll have to unmute yourself.
Mr. Reynolds, would you raise your right hand, sir? Do you solemnly swear or affirm the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Good afternoon, Mr. Reynolds.
Good afternoon, Mr. Borman.
By whom are you employed and in what capacity?
I'm employed by the New Mexico Public Regulation Commission as the Utility Division Director.
As part of your duties in that position, did you review the application by Public Service Company of New Mexico that is the subject of today's hearing?
Yes, I did.
And based upon that review, did you prepare or participate in preparing testimony regarding that application?
Yes, I did prepare testimony for this case.
Okay, and do you have a copy of Staff Exhibit 1?
I do.
Okay, can you identify that document?
That is my direct testimony filed on December 29th, 2020.
It was Staff Exhibit 1 prepared by you or under your supervision?
Yes, it was.
Do you have any changes or corrections to Staff Exhibit 1?
No, not at this time.
If I asked you today the same questions as are set forth in Staff Exhibit 1, would your answers be the same?
Yes, they would.
And are those answers true and correct to the best of your knowledge?
Yes.
Do you thus adopt Staff Exhibit 1 as your sworn testimony in this matter?
I do.
Okay, thank you. At this time, I move admission of Staff Exhibit 1.
Any objection to the admission of Staff Exhibit 1? Staff Exhibit 1 is admitted.
Thank you. Mr. Reynolds is available for further examination.
Thank you, Mr. Borman. Would anybody like to examine or cross-examine Mr. Reynolds? Okay, well, I would. So, Mr. Reynolds, good afternoon.
Good afternoon, Mr. Hearing Examiner.
Good to see you.
Likewise.
Maybe someday we'll be office together again.
For sure. I hope so. Look forward to it.
Me too, definitely. I'd like to, I know you've been here for the duration of the hearing, and we've been discussing heavily your analysis and conclusions regarding the effective capacity commitment and the impact that it has on the kilowatt per year price or cost of the contract. I'm curious, in looking at the contractual provisions, did you consider whether the effective capacity commitment required of Itron might be even lower than 13.5 megawatts?
I did consider that, and I think it's likely to be somewhat lower than 13.5 megawatts. But I guess I was making in part of a conceptual or rhetorical point that the 15 megawatts is overstated by at least as much as I'm testifying to, and possibly more.
I think you, based on the colloquy that I had with Mr. Phillips and other witnesses, it's fair to say that based on your analysis, you've set a new lower threshold or baseline for what this contract actually calls for. Is that fair to say?
I agree with that.
Not to praise you too much.
Please don't.
With that in mind, do you have Mr. Phillips' direct testimony in front of you or available?
Yes, I do.
Could you please turn to the statement of work, the agreement? And it's the page that I was discussing with Mr. Brandt. It's NLP-3, page 26 of 36, or page 13 of 23 of the agreement.
Yes, I'm there.
I'm sorry?
I'm there.
Okay. What I'd like you to try and do for me is, based on the new baseline or threshold, if you will, or effective commitment, I'd like you to recontextualize that page in terms of what the quantity actually is now. So if you put in 13.5 kilowatts in that quantity column, and the unit price is what you and Mr. Brandt agreed, what you have in your exhibit JR-4 at $131.36 for the effective cost per kilowatt. Is that figure in the extended price column correlate to the annual average amount in your JJR-4? That being 1.773, well, that's $1,773 and $1,773,390. And if those figures are wrong, just please go ahead and recontextualize for me based on your analysis and conclusions.
There are a couple of elements in what's being presented on this page, and I don't think it's been, I mean, it's been kind of explained, but the way I read this is that this is an 11-year contract, and the first year is 2021, and essentially, if the commission approves this, and
PNM gets almost $1 million discount for the first year. Is that right?
No, I think what happens is that PNM spends in the middle of that table on the right, $1,910,150 upfront in year one, or 2021 if the commission approves it. And then starting in year two, which would be 2022, and the subsequent 9 years, so a total of 10 years after year one, PNM pays $140,000 a month to Itron, or $1,680,000 to a year, and for the resource, whether it's a 15 megawatt resource, 13.5 megawatt resource, or less. Then PNM gets a discount on some of those future monthly payments of almost $1 million, or $976,250, would be discounted from those monthly payments over a period of time. Exactly what period of time, and I'm not entirely clear about that. But so that's how I see it. And the $112 is essentially the multiplier times the nominal 15,000 kW that results in an annual total of 1,680,000 each year, and divided by 12, $140,000 a month. Now, my calculation on JJR4 again shows that the initial cost of 1,910,150 in year one, and the same annual cost over 10 years, but divided by each year divided by 13,500 kW instead of 15,000, and that gets to an implicit rate of dollars per kW year of $124.44 per kW year, instead of $112 in the page you asked me to look at, page 26 of 36 of NLP3.
So did you look at that page in developing JJAR-4?
I did.
So you could actually plug your table into the contract there and get a more accurate representation of the cost per kilowatt. Is that right?
Yes, that's what I am testifying to in this case. So JJR3 is essentially my replication of NLP3, page 26, as it's stated, and then JJR4 is my adjusted calculations to reflect the lower effective capacity.
All right, excellent. Thank you. Do you know whether PNM or any other investor-owned utility has any other demand? I know the answer with PNM is no to what I'm going to say, but do you know whether any other investor-owned utility, IOU, has any demand-side resources that are not demand-side resources, including DR or DSM resources that are not subject to evaluation by the independent evaluator, the statewide independent evaluator?
I'm not aware of any.
Besides perhaps that interruptible credit option, which, while still effective, is effectively inoperable?
Again, I hear what you're saying about the interruptible credit option, and SPS, I think, has a similar program that is also effectively not operational, but they are included in the, to the best of my recollection, they are included in the utility's overall energy efficiency and load management plan.
In SPS's case, but not the PNM.
Correct. Right, that's correct.
How about EPE?
EPE, I'm pretty confident they do not. They have generally have been less focused on demand or capacity savings than SPS and PNM.
And SPS has a relatively more successful demand response program. Actually, SPS doesn't. Recollection is that it's the Colorado affiliate that has the more robust demand response program for larger customers. Is that right? You recall?
That's my general understanding. I don't think, I wouldn't say that SPS has a more successful or robust program than PNM with respect to demand response. I mean, they do have a a smart thermostat program, which I think is fairly successful.
But actually PNM, excuse me, SPS faces challenges with regard to its customer makeup in incentivizing large customers to participate in a demand response program, doesn't it?
That's correct.
I guess, just generally speaking, I guess I was inspired by your testimony mostly to come up with this theme of the square peg in the round hole. Based on your expertise and listening to the testimony in the case here at the hearing today, do you have any general observations that you'd like to add to your testimony?
I mean, I generally agree with the square peg in the round hole analogy. It's also been referred to as in our discussions about a fudging factor. It's sort of shoehorned into the program. There's 24 megawatts of capacity. And unlike all the other resources that have been approved to replace the San Juan capacity that's being abandoned next year, this one was really I mean, the other resources were all available to study and to model in some significant detail. This was a sort of a penciled resource that had not been subject to competitive RFP and responses to that RFP. So there were a lot of assumptions made to insert it into the CCA1 portfolio.
In fact, it's possible that a better recommendation would have been to, well, strike that. I won't go there because I don't know whether that's neither here nor there. I'll leave it at that. But do you think that, this proposed DR resource, does it become, with your analysis, in particular as shown in JJR-4, that it becomes the most expensive resource in the portfolio, CCA1?
I believe that's correct based on my effective cost per kW year.
And do you think it's a cost-effective resource?
I think that's something that needs to be looked at. I don't know the answer to that at this point, based on.
Will PNM's response to bench request number 1 help in conducting that and doing that analysis?
Yes, I think you're referring to the request for more analysis about how PNM will fill the gap between the 24 megawatts and something less than 15.
Well, if the resource is not approved, what is going to fill the gap of the resource in full, in addition to the 9 megawatts,
right?
The 15 megawatts here.
No, I agree with you. I guess where I was going is that PNM has not provided that analysis for the 9 megawatts that they are proposing to replace in the short-term market. So we don't have that analysis. And if you're asking for analysis if they have to fill a 24 megawatt gap instead of a 9 megawatt gap.
Right.
I have the analysis for either. So I do agree that that analysis would be very helpful.
That was my request, was the 24 megawatts, the whole enchilada.
Correct.
Not the secondary resources. Right?
That's correct. But part of my part of the reason I took the position I did in opposition to this, which, I had to allow that to crystallize over a period of time, was that PNM opened the door to filling a gap with short-term market capacity commitments. So I was following PNM's lead that there is a way to fill a gap of some kind until 24 megawatts of demand response capacity could be firmed up.
Consistent with your criticisms and Mr. Brandt's criticisms of the current proposal in the RFP process.
That's correct. Well, my constructive, intended to be constructive thoughts about it was partly driven by PNM's opening the door to a plan B, so to speak, where we can cover this in the short-term market. And based on that, I felt like, well, if that's the case, I think it's reasonable to suggest that they can cover it for 2 years and then allow the low-hanging fruit to ripen again and pick them for a more robust RFP.
And I want to be clear that I'm not criticizing PNM here, because I have no reason to doubt that PNM, as you state on page 18 of your testimony, has clearly worked hard in assembling the final pieces of the CCA1 portfolio. And it was put under the gun based on the circumstances and came up with an RFP rapidly and under difficult circumstances. I acknowledge that.
Yes, I agree with that.
But the question is this the best, this final more minor piece, is it the final piece of the puzzle? Is it the best piece of the puzzle? And I would observe to the parties that based on the response to the bench request number 1, I would hope to see some analysis in the briefs in chief of the cost benefit analysis, or whatever analysis of whether the resources in the bench request response would be better suited to fill the remaining part of the portfolio or fill PNM's needs, as opposed to demand response plan. And whatever the fair and appropriate answer is and the most reasonable approach, we'll see what that is based on what PNM produces in response to the bench request and based on the analysis of the contractual issue of what actually is the effective commitment that ITRON is required to provide, whether it be 90% or something less than that. The evidence will be what it is.
But regardless of that, what PNM is proposing is something less than 24 megawatts, which is what the commission ordered. And what my proposal is I think would provide a much better chance of PNM achieving or acquiring a 24 megawatt DR resource, but 2 years later than the 15 or 13 megawatt resource they are proposing now. And so in another case, they will not have complied, in my opinion, fully with the order. But I guess what I'm putting forth is, what's best, a partial compliance sooner or likely a more complete compliance 2 years later.
Okay, so I want to be clear. I want to read that bench request, Mr. Reynolds, to you with everybody else listening, to see whether this captures my discussion with Mr. Phillips. What I'm asking for is a study or evaluation that identifies the types and comparative price impacts of substitute resources, assuming the commission does not approve the DR plan and assuming it takes staff's recommendation, it being the commission, to take a holistic approach, that is to undertaking a new RFP for DR resources based on all utility demand resources once the approved energy efficiency and load management program plan for 2021 through 2023 has completed its course. Does that capture the gist of the bench request? Or am I missing something?
Are you asking me, Mr. Hearing Examiner?
Yes, you're going to be looking at the response to the bench request, I assume.
Yes, I will be. And I believe it captures the issues that need to be addressed and analyzed to help make a decision on this case, in this case.
Okay, thank you.
Your Honor, it's a bit unorthodox, but based on what you just said, would it be possible for you to check with Mr. Phillips if he has any necessary clarifying questions to that request?
Mr. Reynolds, let me keep you on the line. I know this is kind of unorthodox, but we're on the record. Is there any objection to that, Mr. Borman?
Not at all. We're kind of, we deal with things how we can deal with them in the present situation. So,
well, I want to get the most accurate information. I want to make sure I'm asking the right question.
Yeah, I understand, and I have no problem with it.
Thank you. Mr. Phillips, did you hear what I read into the record regarding the bench request?
Yes, I did. A couple of clarifying questions. Perhaps Mr. Reynolds can help as well. For the period of time in which we would assume that we are evaluating or waiting to do the RFP for the demand side resources, is that going to be for 2022 and 2023? And we would assume that any expansion or extension of the programs would be ready for the summer of 2024, so that we don't need to have market purchases to cover it in 2024.
That would be my assumption and my intent, Mr. Reynolds.
Yes, that was my intent, and my testimony is for PNM to line up a DR, an alternative DR resource, starting 2 years later than what's on the table now, the ITRON proposal effective January 1st of 2022.
Okay, and so we'll assume that there's market purchases, and I will provide the assumptions for what the pricing and delivery terms of those market purchases would be for 2022 and 2023. And then I thought, Mr. Hearing Examiner, that you were looking for a comparative analysis then of what the portfolio would be if the 24 megawatts of demand response was included, and what the alternative resources would be if it was not included. Is that correct?
Well, yes, but do we have the first part already? Doesn't that depend on the effective commitment analysis?
Maybe I'm getting confused then. I guess I understood the question to be, we're going to assume market purchases for 2022 and 2023. And then there's two paths going forward after that. One that includes the 24 megawatts of demand response and an evaluation of the existing programs. And one that includes just the existing programs plus some alternative resources that you'd like to know? Or am I confused?
Well, the 24 megawatts, what I'm asking for is assuming that proposal is not approved, the program is not approved, what would the situation look like for PNM? What would PNM do?
Correct. And in that short of time, I believe the only option that will be available to us would be to go to the market for some short-term purchases, unless the commission wants us to somehow renegotiate with the current contracts and see if those batteries can be enlarged.
Well, you could add that to the resource mix, if you will, as a potential, as actually a potential counterproposal. Whatever the resource mix is that you come up that makes the most sense. And since you've already analogized this product to, in comparison pricing, which led me to this point, to that point, the comparative pricing to the existing approved battery projects, then I think that that's within the ambit of fair analysis.
Okay. So we would have one portfolio that assumes market purchases in 2022 and 2023, and then there's demand response that comes in 2024 and beyond. There's another portfolio that we look at enlarging some of the batteries that are coming on with the current CCA1 portfolio as an alternative. Was there anything, I guess that's still my confusion though, is there anything you want me to look at where the demand response does not come in 2024 and there's something other? No, okay.
No, it's just based on your agreement with Mr. Reynolds' observation that as an alternative, you take a more holistic approach to demand response. And I don't think Mr. Reynolds is looking beyond 2024, are you?
As far as the new or an alternative DR resource, no. I was looking at a new DR resource starting January 1, 2024, instead of what's on the table now. But it will be a larger, well, I think we should plan for a 24 megawatt effective DR resource starting January 1, 2024. And I'd like to add as well that with what's on the table now, PNM will be going to the short-term market for, call it 9 megawatts for the sake of argument. So there's already that activity taking place based on what's on the table now. If the commission decides to not approve this program, then PNM could be going to the market for larger amounts of capacity and energy. So that's clear.
But the point of it is, it's an interesting discussion, but I'm going to go ahead with it. You've got that shoehorning issue that we're talking about potentially. And so it behooves the commission to look at other alternatives, including potentially the expansion of the battery projects, which are priced at a lower, potentially a lower level than the proposed project here. And I'll just leave it at that. Mr. Reynolds, any observation there?
I think that's a worthwhile alternative. I would say that it would then have to be evaluated relative to the value of a new DR resource starting in 2024 that would allow the third-party implementer to have available layers of fruit that are not available today. So so that it may be a more competitive RFP that may result in a more attractive price.
I missed one word there, one key word, available.
Fruit. I was referring to the low-hanging fruit. So there may be some low-hanging fruit available then that are not available today. And as well as the value of resource diversity that Mr. Brandt mentioned as well. So I mean, I think that's,
Well, all the fruit would be back on the tree though, wouldn't it? At that point with the,
that's my point. That's the point I intended to make, but you phrased it much better.
Ms. Phillips, anything further?
But no, I think I'm ready to go.
Great. I thank you. You're always so cooperative with these bench requests. I truly appreciate it. Sincerely. Thank you. Any redirect, Mr. Borman?
I do not have any additional questions for Mr. Reynolds.
Mr. Reynolds, thank you so much for your testimony. I truly appreciate your efforts as always. Thank you, sir.
Thank you.
All right. We have now concluded the evidentiary phase of the hearing, and I'd like to discuss where we go in turn with the parties, the post-evidentiary phase, the post-evidentiary submissions, I should say, the post-hearing submissions, to be more precise. We have, because first like to discuss the legal standard issue based on where we started this morning at around 9:30. Before we went on the record, I indicated that it's possible that we might have that net public benefit test from Rule 551, the the revised CCN standard, whether that might be applicable to this agreement. And so what I'd like to do is have the parties brief what applicable legal standards, including possibly Rule 551, should be applied to analyze the DR program proposed in this case. Maybe some other standard applicable that has not been mentioned besides that, the ETA analysis for Mr. Fenton's direct testimony, in addition to the approval of long-term purchase power agreements, which includes capacity, may not be a perfect fit, but as Mr. German indicated, that net public benefit test is similar to what would be applied in any event, even though not all of the factors enumerated under Rule 551 to assess long-term purchase power agreements may not be applicable, as they are not necessarily applicable to all long-term purchase power agreements. So I'd like to have the parties address the applicable legal standards. I'd also like the parties to address the contractual analysis of what we've come to call the effective commitment. What is the baseline? What is the actual ITRON commitment, assuming that there's no incentive to, no monetary incentive or other incentive in the contract to produce to PNM or deliver to PNM any more than the contractual quantity at 90% or less. What, based on a careful analysis of the applicable contractual provisions, is the actual effective commitment that ITRON has under the agreement as written. And I'd also like the parties to address, as they were listening to bench request number 1, the response, to analyze the issue of what alternative recommendation that might be made to the commission based on the response and replies to the bench request regarding the alternative resources potentially, I don't want to say proposed, but contained in the PNM's bench request response to bench request number 1. Also, to the extent that there are any other disputed issues of fact or law that have arisen, those should also be addressed as they would be expected to be briefed in a case like this, in the parties' briefs in chief. We have 3 bench requests. First off, with regard to the briefing, are there any questions?
Mr. Hearing Examiner, Mr. Gould, it just occurs to me, I don't know how we would handle this, but it's kind of a process issue. And I understand you're in the process of looking at the evidence and making the decision. So this is a hypothetical in that regard. If the proposal in your recommended decision is to adopt something close to what Mr. Reynolds had suggested, do we need to ask the commission to reopen and adjust its 00195 order? And what would be, we haven't done that in a lot of cases. I can't remember the last time we asked the commission to reopen and re-examine a final order. So that hasn't been appealed. So I'm a little confused about how procedurally we should set that up if that's where we're going.
Well, what would happen first off is, if the recommendation is, it would be to simply reject, if that, and I'm not saying that's what I'm going to recommend, as you.
I understand. Yeah.
But hypothetically, assuming arguendo, my recommendation that the commission accepts is to reject the DR proposal and to follow the so-called more holistic approach with regard to DR resources, with in other words, to allow the current DR programs to run their course through 2023, and then issue the RFP and come up with something for the 2024 period and beyond. Then that's where there would be no need to reopen the case.
But that wouldn't be, if that is the result, again, assuming arguendo, that's what the recommendation is that comes out of this case. That's not consistent with 195 because those resources won't be available to meet the closing date of San Juan. I'm not saying it's a huge problem. I just don't know what the proper procedure would be. So I'll leave it at that.
But the commission might instruct PNM to file something else.
Okay. Yes.
Follow me? We'll see where that goes. But I don't have an answer for it right now. We'll see where the evidence takes us.
Okay, thank you. Appreciate it.
Thank you. Any other questions regarding legal briefing?
Yes, on the bench request for CCAE, you just wanted to know the price per kilowatt used in CCAE modeling, or was there anything else about the models that you needed more information about?
I think that Mr. Brandt talked about providing some of the assumptions, if I'm not mistaken. But whatever information you can give that is relevant to the discussion regarding the proposal that was approved effectively in the CCA1 portfolio, and doing a price or cost comparison would be helpful. Mr. Brandt, could you unmute yourself for a second?
Yes.
Let's go back to that bench request to CCAE. Do you have anything to add or any questions regarding the bench request?
I don't believe so. I can provide you with as much detail as I can on the assumptions around our modeling of demand response in CCAE1, as well as the costs assumed.
Okay, thank you. Now, regarding the bench request, we've had a lot of discussion around bench request number 1. I won't rehash that. We also have bench request number 2 to PNM, which is a list of customer classes eligible to participate in the DR program, acknowledging that what Mr. Phillips indicated, that it's open to all classes, but that it's Itron's going to focus, as I understand it, on customers at 100 kilowatts or above in demand. Is that right, Mr. Phillips?
Yes, sir, that is correct.
I would still go ahead and like to have that in writing since I've already requested it.
Yes, sir.
And then I believe, thank you. And then the final bench request is for a customer bill impact analysis for all classes at the more granular but typical level of consumption per kilowatt hour at various typical levels, as well as for the kilowatt demand for those customers with a demand charge. Are there any further questions regarding the remaining bench requests? Next comes the deadline for providing responses to the bench request. I'll leave that to the parties. We're on an expedited schedule, but there's a lot of work to do here, quite frankly. So PNM, first PNM, what would be a reasonable turnaround time for responses?
Would defer to Mr. Phillips on that, since I think he'll be doing the bulk of the work on preparing our response. What about a week, Mr. Phillips? Does that sound reasonable?
Is there a chance we could shoot for Monday, the 18th? And my rationale for that is the one complicating factor that will need to be done is I'll need to talk to the 4 projects that were selected as a part of the CCA replacement and just make sure, see if they are able to, at this point in time, expand the battery projects and what the under the current pricing terms. If some of them are not, or there's difficulties, we just want to put something in front of the commission and represent it to be true without knowing that it would be true.
And let me back up a second. We're going to need the transcript. We've requested, and PNM has agreed to pay the incremental cost of the expedited portion of the transcript. So this is contingent on when the transcript will be available to the parties.
Mr. Hearing Examiner, I was told a 3-day expedite, which would put it by end of day on Tuesday.
That's the 12th?
Yes, sir.
So PNM, if you could provide, PNM and CCAE, if you could provide your responses to the bench requests by January 18, 2021, does that work?
Yes.
The 18th, Martin Luther King Day, or is it the?
Yes. Yeah, it's a holiday.
Okay. Do you want a day after that, 19th or the 20th? Since it's a holiday. Mr. Phillips?
To be fair, we're all quarantined and I have no life, so.
Why should you be special?
So I just mean, I don't know that the 20th is any better for me than the 19th. I just wanted to make sure we would have the weekend to work on it if necessary.
Okay, so the 19th then. And then responses would be due a week later on January 26th. Excuse me, replies to the responses pursuant to Rule 35K, the rule on additional evidence. Bearing in mind that every time I ask a bench request, there is the possibility that a party may request the opportunity to cross-examine again, and that's a risk I take. I'd rather have a thorough, complete record than have a commission ask me questions that I should have asked, frankly. So replies will be due January 26, 2021. Please write this down because I'm not inclined to issue a follow-up order.
And Mr. Medeiros, if I could interrupt for a second, I just wanted to point out that we did request expedited approval by January 14th. I understand with the post-hearing filings we're having, it looks unlikely we'll hit that date, but I did just want to point out that that's what we requested. And in the scope of work that we filed, any delay beyond January 15th in terms of issuance of a final order would delay implementation of the program on a day-for-day basis. And that's at section 3.1 of the scope of work.
I noted that, Mr. German, but as I said, I think it's unavoidable at this point. I think that the commission, it's fair to say, granted me the discretion to go beyond. And it's something that I discussed with them, frankly, I think, or the general counsel discussed. And so I think I've been granted the discretion to go beyond that. Even just before getting here, I had the discretion to allow more time for intervention and not compress the schedule as much as I did. I think I went through that analysis. That's frankly why I went through the analysis I did in the procedural order with regard to this issue. So I'm sensitive to the timing of it, but I think based on the hearing that we've had, I think it behooves me to have these things included in the record. It's, while there are sensitivities in timing, it is a substantial program with a fairly with a fair price tag, and I think it requires close scrutiny. So with that in mind, I think the earliest reasonable opportunity for bench request responses is January 19, 2021, and any replies will be due January 26, 2021. Now, with regard to the briefs in chief, the filing deadline needs to be informed by the responses to the and replies to the bench request, if any. And so briefs in chief from PNM and staff shall be filed and may be filed by interveners on or before, let's see, we're January 26, 2021. You could begin working on the issue on them. Let's say February 2nd, 2021. Does that work?
Make it work.
That works for PNM.
Okay, February 2nd. And then response briefs would be due a week later. That date being February 9th. February 9th, 2021. And then last is we have the issue of that Mr. Gould raised at the beginning of the hearing, the amended or the proposed recommended decision that PNM filed. What I've done in past cases, perhaps with some of you, is that the last thing to come in, I guess, at the same time as the response briefs would be a amended or revised proposed decision that the parties would either collaborate on or provide alternatives? I know I've done that with SPS several times. What is your thinking on the most efficient, the best use of resources with regard to a proposed decision? Any thoughts on the matter?
I guess this is Brad Borman with staff. I mean, since our positions seem to be somewhat different, all of us, I'm trying to find a way to, I don't know that I can find a way to have a joint RD. So I would imagine that you would have, you know, each of the parties would file what they thought should be the RD. And doing so, I guess, at the time of the response briefs, as you seem to indicate, that seems reasonable to us.
Okay, I'm going to allow PNM the opportunity to file a new amended or a new revised proposed decision.
Sure.
If PNM is so inclined.
Yeah. Yeah, and that the timing makes sense. The timing that Mr. Borman discussed, we could file it on February 9th. But to the extent it is possible to submit a joint proposed RD, we'd certainly like the opportunity to pursue that. So we'll.
You should take that opportunity. It would be helpful to the extent that that's possible. If you circulate a proposed decision ahead of time and get as you've done in the past, I know, and as other utilities have, get the parties' input on it, and to the extent you can arrive at agreement, that would be fine. That would be good. It would be helpful. So, proposed recommended decisions on or before February 9, 2021, filed coterminously with the response briefs. That's the last aspect of the post-hearing submission schedule. And I should note that the requirement that obviously responses to the proposed decision, that deadline being tomorrow, as Ms. Gould asked, yes, that is rescinded. That's no longer required, obviously. And it's superseded by the briefing schedule that I just said. Are there any other matters or questions to address before closing this hearing? PNM?
Not from PNM.
Any intervener?
No.
Nothing from staff.
And nothing from staff. Great, then, with no other matters to address at this juncture of the proceedings, the hearing is concluded and this matter is taken under advisement. Thank you all very much. I truly appreciate your participation. I know it's hard over Zoom, but again, apologies for the delay, but and special thanks to Allison, the court reporter. Thank you so much. With that, this hearing is concluded. I bid everyone a good evening. Take care.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Thank you.
Thank you.